Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on oversight of the United States Department of Homeland Security. In a moment, I'll begin by recognizing myself for an opening statement, and then I will recognize Mr. Conyers when he arrives. I do want to advise everyone, as the Secretary is already aware, many members on the Democratic side are meeting with former Secretary Clinton, and when they arrive, we'll recognize Mr. Conyers for his opening statement. But we're going to proceed because we appreciate the Secretary's time as well. Good morning to everyone, and I want to extend our welcome to Secretary Johnson for testifying before us today for the second time. When Secretary Johnson testified last year, I stated that he was not responsible for the dangerous and irresponsible decisions made by DHS before he was sworn in. I stated that we could only hope that he would bring back a level of adult responsibility to the enforcement of our immigration laws. Unfortunately, since that hearing and under Secretary Johnson's leadership, the deterioration of immigration enforcement has accelerated. DHS under the Obama administration has taken unprecedented steps in order to shut down the enforcement of the immigration laws for millions of unlawful and criminal aliens not considered high enough priorities. This is done under the guise of prosecutorial discretion. Unfortunately, new priorities issued by Secretary Johnson last November have turned the flight from enforcement into a headlong rush. Although DHS previously deemed fugitive aliens to be a priority for removal, under Secretary Johnson's guidelines, these aliens are no longer a priority if they were issued a removal order before January 1, 2014. This means that DHS is disregarding removal orders that have already been issued and wasting the millions of taxpayer dollars spent to obtain the orders. Although DHS claims that gang members are a top priority for removal, gang members are most often convicted under state, not federal law, and state convictions for gang-related activity are ignored under Secretary Johnson's priorities. Secretary Johnson considers as secondary priorities for removal of aliens convicted of significant misdemeanors, such as domestic violence, sexual abuse or exploitation, burglary, unlawful possession of a firearm, drug trafficking, or drunk driving. Yet even this priority falls away if the aliens simply show factors warranting relief. Despite DHS's pledge to prioritize the removal of serious criminal aliens, in the last year, the number of administrative arrests of criminal aliens has fallen by a third, and the department continues to release thousands of such aliens onto our streets. U.S. Immigration and Customs Enforcement has admitted to releasing 30,558 aliens with criminal convictions in 2014. Last Friday, we received data from DHS regarding the recidivist activity of these criminal aliens, ICE released in 2014. 1,423 have already been convicted of new crimes like vehicular homicide, domestic violence, sexual assault, DUI, burglary, and assault, among many others. Because of the failure of this and previous administrations to detain criminal aliens and the failure to vigorously pursue fugitives, there are almost 180,000 convicted criminal aliens currently in removal proceedings who are living in our neighborhoods, and almost 170,000 convicted criminal aliens who have been ordered removed yet are also living free. Under the Obama administration, the total number of such convicted criminal aliens who are not being detained has jumped 28% since 2012, as shown by this chart. The tragic impact of DHS, of the Department of Homeland Security's reckless policies on the safety of Americans was made all too apparent in recent weeks. A convicted criminal alien who had been deported numerous times killed an innocent American woman on a popular pier in San Francisco. ICE had recently issued a detainer for the alien, which San Francisco, a sanctuary city, simply ignored and proceeded to release him. Unfortunately, DHS openly advertises that jurisdictions can ignore its detainers. While testifying this March, ICE Director Saldana expressed her enthusiastic support for mandatory detainers. Then, the very next day, she retracted that statement, made under oath, and called mandatory detainers highly counterproductive. There are now more than 200 jurisdictions, including San Francisco, which refuse to honor ICE detainers. This effectively releases criminal aliens onto the streets with all too tragic results. Secretary Johnson's solution, the Priorities Enforcement Program, is a failure. Politely asking for cooperation from sanctuary cities is a fool's errand. The clear answer to this problem is for DHS to mandate compliance with detainers and for this administration to defend the mandatory nature of detainers in federal court. Unfortunately, the administration has taken neither of these crucial steps to keep our communities safe. Prior to Secretary Johnson's appointment, DHS under the Obama administration went beyond simple non-enforcement and took the leap of granting administrative amnesty to a class of hundreds of thousands of unlawful aliens. Then, last November, Secretary Johnson announced that DHS would grant such deferred action to over 4 million more unlawful aliens. By granting these classes of people deferred action, he would bestow benefits such as legal presence, work authorization, and access to the Social Security Trust Fund and the Earned Income Tax Credit. It is within the constitutional authority of Congress, not the administration, to grant such benefits to classes of unlawful aliens. 26 states believe that Secretary Johnson's planned grant of deferred action en masse would cause them irreparable harm. They challenged the plan in federal court. The judge agreed with the states and has granted a temporary injunction. The court stated that the administration is not just rewriting the laws, it is creating them from scratch. An appeals court has rejected the administration's request of a stay of that injunction. While the continuing injunction against the unconstitutional affirmative grant of deferred action is a welcome development for the health of our Constitution, the court was clear that it was not interfering in any way with Secretary Johnson's non-enforcement of our immigration laws. The American people have rightly lost all confidence in this administration's willingness to enforce our current immigration laws. This has become the single biggest impediment to Congress's ability to fix our broken immigration system. I look forward to the testimony of Secretary Johnson. And now it's my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman. Members of the committee and our distinguished witness, Secretary Jay Johnson, when you last testified before this committee, I said that given his distinguished record of public service, I could think of no person better equipped to lead the Department of Homeland Security and to carry out the President's directive that we carry out our immigration policies in the most humane way possible. Much has happened in the past year, and I'm pleased to say that I stand by my initial assessment, which is not to say, Mr. Secretary, that there's not still a great amount of work to do. In your written testimony, you speak in great detail about your efforts to counter the global terrorist threat, which has become decentralized, more diffuse, and more complex. I agree that ISIL and Al-Qaeda have moved to a new phase of the conflict, recruiting at risk individuals hoping to inspire attacks in the West. The department rightly combats this threat with a combination of heightened security measures and community outreach. But I wonder if the department has also taken note of a recent study by New America which demonstrates that since September 11, 2001, nearly twice as many people have been killed by white supremacists, anti-government fanatics, and other non-Muslim extremists than by radical Muslims. Another study released last month by the Police Executive Research Forum shows that state and local law enforcement agencies feel far more threatened by right-wing and anti-government terrorism as they are about ISIL-inspired attacks. And I hope that you will provide us with some assurance today that our priorities are in order and that the department focuses on homegrown extremism with the same forcefulness it has shown in countering threats from abroad. The immigration actions you initiated last November through a series of memoranda should make our immigration enforcement system smarter, more efficient, and ultimately more humane. Carrying out these reforms clearly has not been easy, but meaningful reforms rarely are. Your job has been made harder by the refusal of conservative leadership in the House to allow a vote on the immigration reform bill that passed the United States Senate 2 years ago with 68 votes. It has been made harder by their refusal to consider the bipartisan House bill, H.R. 15, which had 201 co-sponsors in the last Congress, and is made harder by the barrage of litigation that you've had to fight off as you've attempted to implement common sense and entirely lawful immigration reforms. At the end of the day, it only makes sense that people who commit serious crimes and pose a danger to the public should be our highest priorities. Those with strong ties to this country, the spouses of citizens and permanent residents, the parents of citizens and dreamers, and those who have worked productively in the United States for many years should not be. Who could disagree with that? We're already seeing a positive impact from the reforms that have been implemented, and I thank you for your tenacity. Certainly, we may disagree about the implementation of some of the enforcement reforms, and that's something that we will monitor, but I believe we're heading in the right direction. One area that is particularly in need of urgent reforms involves the detention of mothers and children in secure jail-like facilities. You recently acknowledged that substantial changes must be made to the current policy of detaining thousands of these families, some for many months and some for longer than a year. We're monitoring these changes because we know from experts that family detention is causing real, lasting damage to these children. We look forward to continuing to work with you to ensure that all aspects of the Department of Homeland Security operate in a way that reflects our American values and continue to honor the contribution of immigrants to our great nation. One final note. The chairman spoke about the tragic death of Katie Stennell, an innocent young woman who was walking with her father on a San Francisco pier. Our hearts go out to her family. But as we think about the proper way to respond to this situation, we must make sure we do not adopt policies that would diminish public safety and undermine our commitment to the Constitution and civil liberties. And so I ask Mr. Chair unanimous consent to enter into the record yesterday's New York Times editorial entitled "Lost in the Immigration Frenzy." I thank you, and I look forward to hearing the testimony of our witness, and I yield back the balance of my time.
The chair thanks the gentleman, and without objection, the editorial will be made a part of the record.
Thank you, sir.
Without objection, all other members' opening statements will be made a part of the record as well. And we will again welcome our distinguished witness. And Secretary Johnson, if you would please rise, I'll begin by swearing you in. Do you swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. Let the record reflect that the witness responded in the affirmative. and we'll proceed to the introduction. J. Charles Johnson was sworn in on December 23, 2013 as the 4th Secretary of Homeland Security. Prior to joining DHS, Secretary Johnson served as General Counsel for the Department of Defense, where he was part of the senior management team and led more than 10,000 military and civilian lawyers across the department. Secretary Johnson was General Counsel of the Department of the Air Force from 1998 to 2001, and he served as Assistant U.S. Attorney for the Southern District of New York from 1989 to 1991. In private law practice, Secretary Johnson was a partner in the New York City-based law firm Paul Weiss, Rifkin, Wharton, and Garrison. Secretary Johnson graduated from Morehouse College in 1979 and received his law degree from Columbia Law School in 1982. Mr. Secretary, your entire written statement will be entered into the record, and we ask that you summarize your testimony in 5 minutes or less, and we welcome you again.
Thank you, Chairman. I can do that. You have my prepared testimony. As you noted, Chairman Goodlatte, Congressman Conyers, members of this committee, it's a pleasure to see you again. Chairman, last time I was here, I noted, or you noted, that 38 years ago I was an intern for Congressman Hamilton Fish, who was a member of this committee. I recall, after talking to some of the congressional interns who were here, 38 years ago, very vividly, Congressman Fish sent me to a hearing of the Senate Judiciary Subcommittee on the Constitution over on the Senate side. 38 years ago this month. I remember it like it was yesterday. The witness was talking about the abolition of the Electoral College. And in the middle of his testimony, he had a massive heart attack and dropped dead. I hope not to make such news today.
We hope and pray not either.
In all seriousness, as you know, Chairman, the department has many missions. We have 22 components, 225,000 people. We're focused on a number of things. My top priority for 2015 has been management reform, ensuring that our department functions most effectively and efficiently for the American people. I'm pleased that we have filled almost all the vacancies that existed in my department when I came in 18 months ago, most recently with the Senate confirmation of our new TSA Administrator, Vice Admiral Pete Neffinger. We're doing a number of other things to reform and make more efficient how we conduct our business. We're focused on aviation security. Of course, we're focused on counterterrorism, which in my view remains the cornerstone of our department's mission. We're focused on cybersecurity. I refer the members to an op-ed that I submitted, which appears today in Politico, on federal cybersecurity and how I think we need to improve our mission there and the things we are doing in DHS to improve our federal civilian.gov network. On immigration, respectfully, it is a fiction to say we are not enforcing the law. Apprehensions are down. They're down considerably from where they were a year ago, but there are still apprehensions daily, in particular on the southern border. I'm pleased that the spike we saw last summer on the southern border has not returned, and apprehensions, which are an indicator of total attempts to cross the border, are down considerably. If the current pace continues, apprehensions will be at the lowest since sometime in the 1970s. In terms of enforcement and removal, without a doubt, the new policy that I announced and am directing prioritizes threats to public safety and border security. Without a doubt, we are moving increasingly in the direction of deporting criminals. Absolutely, and I stand by that because I believe it is good for public safety. I am pleased that of those in immigration detention now, 96% are in my top 2 priorities for removal. 76% are in my top priority for removal. That is, those apprehended at the border, convicted felons. That is the direction we're moving in with the resources we have I believe we need to continue to focus our resources on criminals, on threats to public safety, on border security. Part of that is fixing our relationship with state and local law enforcement. The Secure Communities program had become legally and politically controversial to the point where something like 300 jurisdictions had enacted or imposed limitations on their law enforcement's ability to cooperate with our immigration enforcement personnel. That needed to be fixed because it was inhibiting our ability to get at the criminals. And so what the President and I did was to replace the Secure Communities program with the new Priority Enforcement program, which I believe resolves the legal and political controversy. And we are actively reaching out to state and local law enforcement and jurisdictions to introduce the program and encourage them to work with us. Of the 49 biggest, I'm pleased to report that some 33 have indicated an agreement and a willingness to work with us. Only 5 of those 49 have said no so far, but we're going to go back to them. This is a work in progress. The County of Los Angeles is a big one that has agreed to work with us in the new program to more effectively get at threats to public safety. That is the direction I believe we should go in for the sake of public safety, homeland security, and border security. As the chairman referenced, our deferred action program for adults is pending right now in litigation. The district court issued an injunction. That matter is on appeal right now. Oral argument on the appeal was last Friday. We await the decision. And Chairman, Congressman, I look forward to your questions. Thank you.
Thank you, Mr. Secretary, and I'll recognize myself. You claim to prioritize immigration enforcement against criminal aliens, and the number of available immigration detention beds you utilize continues to fall. 34,000 are authorized, only 24 to 26,000 are being utilized. So can you explain to me the continued increase in the number of convicted criminal aliens in removal proceedings who have already been ordered removed, who are not being detained by DHS? The number of these convicted criminal aliens allowed on our streets has gone up by 28% in less than 3 years. And again, I'll direct your attention to the chart over there. From 270,000 to almost 350,000. These people are out on the streets, and many, many of them are committing new crimes. And I would very much like you to explain how this priority system is working when you're not fully utilizing it, not removing 350,000 people who have been ordered removed, and not even using the capabilities that the Congress is paying for.
Well, last time I looked, the number of those detained in immigration detention has been going up. Last time I checked, it was up to around 31,000. That's a day-to-day report I get, and the last time I checked, it was up to around 31,000. That is less than the full capacity that Congress has given us of some 34,000, to be sure, but it is moving in the direction.
Given that there's 350,000 on the street, should we be providing you with additional capacity, or when are you going to get to the 34,000?
Well, like I said, it's trending in that direction. We have, as you know, established greater capability to detain those who bring their children with them, and I have issued policies to reform those practices because of the special considerations that go into dealing with children. But we have increased the capacity. It is going up, and the reason I think, one of the reasons I think it's lower than 34,000 is, frankly, the apprehension rates are lower, and because of the problem we had with Secure Communities, which was inhibiting our ability to conduct interior enforcement.
Well, let me ask you about that. Why do you think that cooperation with ICE and their detainers should be voluntary?
Well, if I could just finish my sentence. Some
Sure.
12,000 detainers last year were not acted upon by state and local jurisdictions. I do not believe that we should mandate the conduct of state and local law enforcement through federal legislation. I believe that the most effective way to work with jurisdictions, particularly the larger ones, is through a cooperative effort, and I believe state and local law enforcement believes that as well, through a cooperative effort with a program that removes the legal and political controversy. One of the
Well,
problems...
let me ask you about that. Isn't it true that some of the worst offending jurisdictions have declined to even participate in your new priority enforcement program?
I would disagree with that, sir.
It's my understanding that 5 priority A jurisdictions, the highest priority, have said outright no.
And as I indicated a moment ago, 33 have indicated a willingness to participate in one way or another. Of the 49 top, 11 are still considering it, and we've contacted literally hundreds, but the 49 I've mentioned are the 49 top priorities because they are the largest jurisdictions. And the overwhelming number have indicated a willingness to work with us.
Of the 276 so-called sanctuary cities where they have publicly taken a position to not cooperate with ICE, last year some 8,000 criminal aliens were released by those communities onto the streets of their communities and of this country. And in the short time since those 8,000 were released, they have already committed nearly 1,900 new crimes. Why wouldn't it be a priority to do everything possible to mandate, influence, whatever the case might be, for them to honor ICE detainers rather than to see this occur? Now, I have to say the department is not operating with clean hands when they go to these communities and say don't release 8,000, because the department released 30,000 last year under their own procedures. And again, that helped to contribute to this growing list now of nearly 350,000 individuals who are either under a deportation order or have deportation proceedings pending, who have been released by ICE or by others and are out on our streets.
Well, if you're asking me, should we reduce or eliminate the criminals who are undocumented who were released by sanctuary cities?
And by the department.
I agree that we should work to reduce that number. Absolutely. I agree with the spirit of your question.
But the trend's going the wrong way.
I disagree that through federal legislation we should mandate how state and local law enforcement relates to us. I don't think that that's going to solve the controversy in the courts. And in terms of the 30,000, as you know, Chairman, I have issued...
How about incentivizing them?
As you know, Chairman, I have issued new guidelines to deal with releases of those who have been convicted of something from immigration detention, to tighten up on it, higher level approval authority, and that we should no longer release somebody for budgetary or reasons of lack of space. We will find the space if there's somebody that we think should be detained, and we can detain them consistent with the law. That has been my directive. I want to see that number go down too.
Thank you. Gentleman from Michigan is recognized.
Thank you, Mr. Chairman, and welcome, Mr. Johnson. We're very pleased to have you here. And I was just looking over your article in the newspapers today about cybersecurity. And you say, often sophisticated actors penetrate the gate because they know they can count on a single user letting his guard down. But we've increased and will continue to increase with Congress's help to do much more. Do you have an additional comment about that? I'm going to put this in the record.
Yes, Congressman, I have been struck by the fact that very often the most sophisticated, far-reaching attacks, whether in the private sector or in the government, by the most sophisticated actors, often starts with a simple act of spear phishing. Someone opened an email that they shouldn't have. And so a large part of our efforts have to be education of our workforce about not opening suspicious emails they don't recognize.
Thank you. On immigration enforcement priorities, over the past 6.5 years, this administration has set many new immigration enforcement records. Over the first 6 years, the number of people removed was so much greater than it had been under past administrations that the president was famously described as the deporter-in-chief. The Washington Post recently reported that your department is now on pace to remove fewer people in the current fiscal year than in the past fiscal years. Can you explain why the removal numbers went down in this past year?
Well, as I mentioned, Congressman, I'd like to see us move in the direction of focusing on threats to public safety, and that's what we're doing. While the overall number of deportations has been going down, an increasing percentage of those we detain, and hopefully those we ultimately remove, are convicted criminals, recent border arrivals illegally, and threats to public safety. That is the direction that I believe we need to go in.
Good. Let me ask you about the decision to replace secure communities with priority enforcement program. I understand the secure communities, the fingerprints of every person arrested and booked for a crime by local law enforcement are checked not only by the FBI, but also against Department of Homeland Security immigration records. Will that interoperability still be present under the priority enforcement program?
Yes.
Excellent. Now, the Montgomery County Chief of Police recently said his office notifies ICE when serious criminals are set to be released, and ICE is always able to get there on the day of release to assume custody. Would you say ICE will generally take appropriate action when notified about the release of a serious criminal?
We will generally take appropriate action to avoid the release of a serious criminal, absolutely, yes.
Very, very good. Finally, can you comment on the shooting of Kate Steinle in Pennsylvania? In general, how do you respond to people who say that our southwest border is not secure? How secure is our southwest border compared to other times in our history?
Over the last 15 years in the Clinton, Bush, and Obama administrations, we, and I include in the statement we, the Congress as well, have made historic investments in border security. For example, 15 years ago, there was only 70 miles of fence on the southwest border. Now there is 700 miles of fence. We are up to 18,000 and change in terms of Border Patrol personnel on the southwest border. And I believe that is reflected in the numbers. In the year 2000, apprehensions on the southern border were 1.6 million. In recent years, they're down around 400,000. This year, I suspect, will be somewhere in the 300,000s, even lower. That is due in very large part to the investments we've made in border security with this Congress. And I want to continue that progress through investments in technology, surveillance equipment, and so forth. In terms of the San Francisco case of
Can I squeeze in
Kate Steinle, and I
Thanks.
hope I pronounced her last name correctly.
Thank you.
Tragedy.
Just finally, I understand that Mr. Lopez Sanchez has returned to the country multiple times after being deported, but in most instances, hasn't he been apprehended right away? Can you give us a little illumination on that subject?
My understanding is that he was deported 5 times and returned 5 times, and he was prosecuted for unlawful reentry 3 times and served fairly significant jail sentences. He was in BOP custody, serving his last sentence. We put a detainer on him. Then he was transferred to the San Francisco sheriff. We put another detainer on him, and he was released. My hope is that jurisdictions like San Francisco County, will cooperate with our new program. I was pleased that Senator Feinstein wrote the mayor and asked that San Francisco participate. As the sheriff himself has acknowledged, I personally met with the sheriff in April to ask for his participation in the PEP program, along with other San Francisco area sheriffs in the month of April. And so, as I said, I'm making the rounds with a lot of jurisdictions. My deputy secretary and I and other leaders in DHS have been very, very active for the purpose of promoting public safety to get jurisdictions to cooperate with us on this.
Thank you, Mr. Secretary. Thank you, Mr. Chairman.
Thank you. The chair now recognizes the gentleman from South Carolina, Mr. Gowdy, the chairman of the Immigration and Border Security Subcommittee, for 5 minutes.
Thank you, Mr. Chairman. I also want to thank the gentleman from Texas for letting me go in his spot. Mr. Secretary, I've been on this committee for almost 5 years now, and I have listened as witnesses primarily called by our colleagues on the other side of the aisle have repeated with almost catatonic frequency certain phrases like citizenship for 11 million aspiring Americans, as if 11 million of any category could all pass a background check. Phrases like functional control of the border. Phrases as benign sounding as sanctuary cities. And I've listened pretty carefully, Mr. Secretary, as I've heard argument after argument after argument made against empowering state and local law enforcement to actually enforce immigration laws. Have you had a chance to look at the criminal history of Mr. Lopez Sanchez?
I believe I have, yes.
It dates back to 1991. The criminal conduct occurred in 5 separate states. He's committed local, state, and federal crimes. He was and is, by any definition, a career criminal. He violated at least 3 separate statutes when he simply picked up the gun before he shot and killed an innocent woman walking with her father. So, to me, Mr. Secretary, he is Exhibit A that we must not have functional control over the border, or he wouldn't have re-entered so many times. And he is, I'm assuming, not able to pass anyone's background check. I would hope that somebody with this criminal history couldn't even pass our friend in the Senate's comprehensive immigration reform background check. Now, I want us to look at a legal issue in a second, Mr. Secretary, but I want to read a quote to you, and I want to ask you if you know who said it. I want people who are living in this country undocumented to come forward, to get on the books and subject themselves to a background check so I can know who they are, and whether it's the current DACA program or a path to citizenship, whether it's deferred action or earned path to citizenship, from a Homeland Security perspective, I want people to come forward. Do you know who said that?
Well, I don't know if I said it or not, but that is consistent with my own sentiments, so I could have said that.
You did say that. Now, I want you to tell me what in Defendant Lopez Sanchez's background leads you to believe that he would, to use your words, come forward.
Well, clearly, he is not the type of person that would ever qualify for any sort of deferred action.
I know that, nor is he the type of person that would come forward, Mr. Secretary. So my point is, when you have a porous
sentence, sir?
Sir?
May I be allowed to speak?
You are welcome to answer the question that was asked, yes.
Well, give me a chance, please. He is not any kind of person who would qualify for any type of version of deferred action in my book or earned path to citizenship. He is a criminal, a dangerous criminal, multiple times over. When we talk about encouraging people to come forward, what we're talking about are people who we hope will report crime, who will participate in American society fully. Obviously, somebody like this is not coming forward.
No, he is not coming forward, Mr. Secretary. I'll let you answer the question, Mr. Secretary, but I'm not going to let you run out the clock. You're right, he's not coming forward, and he doesn't need to get on the books because he's already been on the books. In fact, better than being on the books, Mr. Secretary, he was in federal prison. So I want to know, why was somebody in federal prison with a federal detainer on him released to a sanctuary city?
You'd have to ask the Bureau of Prisons.
Have you asked the Bureau of Prisons?
We've had a detainer on him, both when he was in BOP custody and when he was in the custody of San Francisco.
I know you did. My question to you is...
I'm quite sure that there are a lot of questions being asked right now. In my book, he is Exhibit A for why jurisdictions need to work with our priority enforcement program. Secure Communities was not working. There were over 12,000 detainers of mine that were not acted upon.
Well, then why don't you make them
Program
mandatory, Mr.
was
Secretary?
not working.
Why don't you make the detainers mandatory? If cities like San Francisco are not complying with federal detainers, why don't you make them mandatory?
I think that would be a huge setback in our ability to work with state and local law enforcement, and I suspect they would agree as well.
Well, I do not agree, and I'll tell you why I don't agree, Mr. Secretary. What I find ironic is you are not willing to mandate federal detainers, but you are willing to mandate that state and local law enforcement cannot assist you in enforcing immigration laws. I mean, help me understand that. You can empower a city like San Francisco to ignore federal law, but you won't empower state and local law enforcement to actually enforce immigration laws. Help me reconcile that.
Can I speak?
Yes, sir. You can have the rest of the time.
Thank you. Thank you for giving me 7 seconds.
Now, you take all the time you want to answer the question, because
Sir,
I think it's important.
I'm sure you're aware of this. The Secure Communities program was hugely problematic in the courts. The courts were saying that state and local law enforcement does not have the authority under the due process clause of the Constitution to hold people until we could come and get them. Last time I looked through federal legislation, you cannot rewrite the due process clause of the Constitution. So that is a problem. I do not believe that mandating through federal legislation the conduct of sheriffs and police chiefs is the way to go. I think it will be hugely controversial. I think it will have problems with the Constitution. I want to see us work cooperatively with state and local law enforcement, and I believe that they are poised to do that.
Well, my time is up, Mr. Secretary. The last time I looked, we had a supremacy clause. And federal law trumps state law, so God knows it trumps the law in San Francisco. And when I hear the phrase sanctuary city, as benign sounding as it is, it may have been a sanctuary for that defendant, but it sure as hell was not a sanctuary for a young woman walking with her father. So at a minimum, change the name of whatever benign sounding program cities like San Francisco want to follow, and the money ought to be cut, and I would hope that you would insist that federal detainers be honored and not be discretionary. And with that, I would yield back to the chairman.
Chair thanks the gentleman and recognize the gentleman from New York, Mr. Nadler, for 5 minutes.
Mr. Chairman, first, I want to welcome Secretary Johnson. And as the former chairman of the Constitution Subcommittee, I'd like to remind Mr. Gowdy that the Supremacy Clause does not trump the Fourth Amendment, and that the federal courts have held detainers unconstitutional as violations of the Fourth Amendment. So when Secretary Johnson said there were troubles in the courts, there were indeed troubles in the courts. And I want to commend the administration for trying to follow a policy that is not unconstitutional and illegal on its face, as the prior policy was. Now, Secretary Johnson, I have heard significant concerns about mistaken and even fraudulent issuance. I realize this is off the one topic we're supposed to talk about. Of O-1B and O-2 visas to aliens coming to the U.S. to work in the motion picture industry. Movie and TV production jobs provide the livelihood for a great many New Yorkers, so I take very seriously allegations that CIS is improperly allowing unqualified aliens to fill those jobs. I'd like your agency to take a serious look at these assertions or allegations. Would you commit to working with me on this issue?
Yes.
Thank you. On an allied topic, we have been asked, and I've looked at it sympathetically, frankly, to increase the number of H-1B visas. And in fact, we voted out of this committee an increase of 50,000 H-1B visas, which most of us on our side of the aisle voted against only because of the provision to eliminate an equivalent number of diversity visas. But the assertion that we need more H-1B visas because we have to bring engineers and others to this country that to fill positions that we can't fill here, we've heard that repeatedly. And yet, we see these recent stories about the Disney company and others laying off hundreds of their own American employees who were then forced to train foreigners who came here on H-1B visas to replace them. Now, if that is true, there's a very serious failing of the H-1B program, and it being used to displace American workers rather than to supply people for slots that American workers can't fill. Is the department looking into that as to how that program is being abused, and can it be fixed properly?
Through the H-1B program, those who hold the visas are not supposed to replace Americans with the jobs, as you know, as you pointed out. Any such allegations are very troubling to me. I believe that such matters should be investigated. I also believe that Congress can help in this regard. I think that Congress can help through increased enforcement mechanisms for situations where an employer does in fact replace American workers with H-1B holders. That is a recommendation that has been made to me, and I support that.
Thank you. Mr. Secretary, the United States has a long-standing commitment to refugee protection, and we pride ourselves in our open and welcoming refugee and asylum laws. I understand that these laws need to be balanced with legitimate border security initiatives, obviously, but I'm concerned that in our quest to expedite the removal of individuals from our country, we may be deporting those with serious persecution claims. Recently, DHS instituted a pilot program expediting the deportation of Central Americans beyond the normal expedited removal process. These detainees are apprehended by CBP and then detained by ICE away from the general population. They are not given any Know Your Rights presentations or access to attorneys and are deported within a matter of days. Advocates on the ground are being told that these detainees are being held in facilities, particularly in the Port Isabel Detention Center and other facilities in South Texas. I'm also concerned that we may have transferred our burden of border security to the Mexican government, and that they are summarily deporting Central American refugees without offering them any protection under international law. Under U.S. pressure, Mexico has more than doubled its detention and deportation of Central American children, families, and adults over the last year without commensurate resources into identifying and offering protection to legitimate refugees. I find these practices troubling, given that there are several news reports about the horrific violence in the region, especially against women and girls, and articles stating that Central Americans are being killed upon their deportation from Mexico and the United States. I'd like to enter some of these into the record, Mr. Chairman. And
If the gentleman will at some point designate which ones, we will put them in the record.
Law enforcement involves enforcing those laws that provide protection from persecution too, and we have an obligation to make sure that we don't undermine those that at our borders or at our friends' borders. What is the administration doing to ensure that Central Americans' refugees' international protection claims are being honored by both our government, and that is to say that they have an adequate opportunity to make their claims with proper legal assistance, and by the government of Mexico?
Well, a couple of things there, Congressman. First, we have prioritized among our CIS personnel interviews of people on the border, particularly from Central America, who may have a reasonable fear claim and a credible fear claim. In the most recent guidance I issued, I directed that these interviews be conducted in a reasonable period of time as quickly as possible. My hope is that we can get those done in, on average, around 14 days after apprehension. So that's one thing. When it comes to refugees, the other thing that we have begun, which I'd like to see more use of, is in-country processing in Central America. Advice we got last summer when we were dealing with the spike there is we need to offer people a lawful, safe path to the United States. And so we set up in-country processing, the ability to interview kids in the 3 Central American countries who have parents who are lawfully here to see if they would qualify for refugee status. Frankly, not enough people have taken advantage of the program. It's in the low thousands. I'd like to see more use that method versus trying to make the journey through Mexico, which is very dangerous and crossing our border illegally. And so we're encouraging people to make use of that program in Central America. And I want to see us publicize it, put emphasis on it, because it is the lawful, safe path to come to the United States.
My time has expired. I yield back. Thank you.
Chair thanks the gentleman and recognizes the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman. I'll preface my my questions with just a comment, and that's we've mentioned the Secure Communities Program several times this morning, Mr. Secretary, and I would just note that the administration never went to court to defend the Secure Committees program when the issue was before the courts. But let me turn to my questions. First of all, what is the administration's position on sanctuary cities?
I'd like to see,
Does it have one?
well, yes, in the sense that I want to reduce, if not eliminate, the jurisdictions that don't want to cooperate with us. And
But as far as the
whatever
existence of
label-
actually the cities, has the administration actually come out and either condemned them on the one hand or condoned them on the other hand?
Well, whatever label you put on it, there are a whole lot of jurisdictions, something like 300, that
What would you,
do
what's
not
the definition of a
cooperate with our
sanctuary
immigration
city?
enforcement personnel.
What,
I
what,
want
what's your
to
operating
eliminate that.
definition of a sanctuary city?
There are so many around. I just know that there are 300, something like 300 jurisdictions that have enacted ordinances, executive orders, acting pursuant to state law that will not cooperate with us because of the controversy around the Secure Communities Program.
So in essence, these
wanna end
communities are refusing to cooperate with the federal government in the enforcement of the federal immigration laws. Would that be a fair
To one
representation?
degree or another.
To one degree or another. Okay, thank you. And one of the things that's so annoying, so aggravating, so frustrating to a lot of us and a lot of people that bring this whole topic up with me is the fact that this administration seems to be anxious to aggressively pursue communities, states that are enforcing the immigration laws. Arizona is an example, and all the way U.S. Supreme Court on that. So when a state is enforcing our immigration laws or immigration laws, we go after them. We pursue them. We basically, in that case, stop them. However, we have communities all over the country that are refusing to enforce the immigration laws, and we saw this tragic incident in California with this totally innocent 32-year-old woman who was brutally murdered by somebody who shouldn't even have been here. The administration really, in essence, hasn't actively opposed cities that are flaunting our immigration laws. Isn't that, can you understand that frustration a lot of people have?
Well, all I know is I've been spending a whole lot of time of my own meeting with mayors, governors, county execs, sheriffs who have been opposed to cooperating with us to encourage them to eliminate those barriers. That has not included Arizona. That's including a lot of very large jurisdictions that have passed these types of laws to encourage them to repeal them or interpret them in a certain way consistent with our new program, which is aiming at getting at the criminals.
Let me switch gears. Has the administration reached out to the Steinle family, to your knowledge?
To who?
To the family of the woman who was brutally murdered by this individual who had committed 7 different felonies in 4 different states, in my understanding, who'd been deported, kept coming back, and has the administration reached out to that family?
I'm sorry, I don't know the answer to that question, sir.
Because I would just note that the administration has reached out in a whole range of homicide cases, criminal cases around the country, and I'm not being critical of them having done that. I think that certainly there are times when the administration should do that, but there are also times perhaps they need to do that. I would
I don't know the answer to
strongly
that.
recommend that. Could you check into that and see if they have or haven't?
Speaking for myself, I have developed a practice of reaching out to every sheriff or commissioner or chief who has had a law enforcement officer who has died in the line of duty. Myself, I write a letter personally.
My understanding is they have not, but I would ask that the administration check in it. I'm almost out of time, but let me ask you, the fence, how long is our border with with Mexico?
2,700 miles, I believe.
And how much of the fence is actually complete at this point?
700, pursuant to congressional direction, something around 700. Yes, sir.
Okay. What did the administration do back in 2010, which suspended expansion of the virtual portion of the fence?
Well, my understanding is that the 700 miles, it's 700 and change, was built pursuant to congressional mandate. I know that there was some litigation around an environmental issue. I also know that a lot of the southwest border is very remote. As I'm sure you know, some of it includes the Rio Grande. Other parts of the border are very mountainous. And so the fence we have built has been built in places where it makes the most sense to have a fence.
And my time's expired, but just let me conclude by noting that that's one of the other things that I think is very frustrating to the American public, is the fact that the law says the fence is to be built. I know not all of it is a fence, as we all understand it. Some of it's virtual. But the length of time this has taken and the environmental lawsuits that have been filed and all the rest, the fence needs to be completed. We need to have a secure border. And I yield back my
I
time.
believe that it's almost all completed pursuant to the mandate we have from Congress, sir.
I don't think that's correct, but I'll follow up on it. Thank you.
Chair thanks. Gentleman recognizes the gentlewoman from California, Ms. Lofgren, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Secretary, for being here and for the work that you do on behalf of our country to keep us safe. It is a tough job, but you have approached your duties with skill and dignity, and we very much appreciate that. I want to touch just briefly on the tragedy in San Francisco, the young lady who was walking with her father. Obviously an outrageous situation that she was shot and killed. And I think whenever an innocent citizen loses their life, it should cause us to review what are the policies, what could be changed that would make our community safer. And some have said, well, we ought to do mandatory sentencing, but my understanding is Mr. Sanchez had finished 4 years in prison for the prosecution, so it doesn't appear that that is necessarily the answer. One of the questions I wanted to explore was the policy of transferring from the Bureau of Prisons to a locality on a warrant. It's my understanding that there was like a 20-year-old warrant. It was a bench warrant for Mr. Sanchez, but the underlying offense was possession of a small amount of marijuana. Now, I don't know. I mean, we've asked the Bureau of Prisons, what discretion they had, and clearly, if you had an outstanding warrant against somebody who committed a crime, 2 weeks ago, you don't want the Department of Homeland Security to thwart that criminal prosecution in a locality. But if you have a very old warrant with an offense that, probably wouldn't be prosecuted, is there some way that we could explore either clearing those warrants if there's no intent to prosecute? I mean, in that case, you would have a situation where probably the arresting officer's retired, there would be no witnesses, you couldn't really have an effective prosecution. Further, in the state of California today, possession of a small amount of marijuana is infraction. I mean, it doesn't even give rise to a prosecution. What are your thoughts on that process?
I agree with the spirit of your question. I think that in a situation where the Bureau of Prisons has someone that they are about to release because that person has completed his sentence, and there's an immigration detainer, and there's a 20-year-old warrant on a marijuana charge, there ought to be some discretion and balancing built into that so that
Or maybe some communication with the locality to find out whether they intend to prosecute?
Look, I think we need to look at this question. It may be that they give priority to a criminal warrant, which in all cases is not necessarily the best outcome. And so I want to look at the question of whether or not we and BOP can work more effectively together to make the appropriate assessment that it's better that this person go to immigration detention versus go to a jurisdiction on a 20-year-old warrant. So,
Well, I'm glad to hear that, and I would like to keep apprised of the progress in that, because I think it's an important element of this situation that has sort of not been examined. I want to talk today about the GAO report just released today. You may not have had a chance to review it, but it really talks about the manner in which the DHS is screening and caring for unaccompanied children when it comes to Mexican children at the border. And this is an issue that I've raised in the past, both publicly and privately, that Mexican children under the age of 14 are presumed not to be competent to make a decision about whether to voluntarily return. But what the GAO found is that we're not really getting the kind of examination that the law envisioned under the trafficking provisions. And it does trouble me, and I know there are several members on both sides of the aisle who are concerned. You have a child who may be a victim of trafficking. They may have been a victim of sexual abuse, and yet their interrogation is conducted by a uniformed officer who may or may not speak their language in front of other people, other children. You wouldn't have a police agency in the whole United States that would interview a child sexual abuse victim in that manner. So I'm wondering, now that we have the GAO report, whether we can revisit how we are doing these interviews and whether we might take a clue from police agencies around the United States to make sure that potential sex trafficking victims who are children are interviewed in an appropriate setting by skilled, non-uniformed people so that we can get the truth and whether they're in fact a victim or whether they're not. When you've had a chance to take a look at that report, could we discuss this further?
I'm aware of the report and its conclusions. I haven't had a chance to carefully study it, but it's something that we will look at. Yes, ma'am.
Thank you. My time's expired, Mr. Chairman.
Chair thanks the gentleman. Recognize the gentleman from Virginia, Mr. Forbes, for 5 minutes.
Thank you, Mr. Chairman. Mr. Secretary, it's always good to see you. Thank you for being here.
Always good to see you too, Mr. Forbes.
At the opening of this hearing, the ranking member, for who I have enormous respect, complimented the conservative leadership of the House for impacting and even slowing some of the policies of this administration. I assumed he was talking about the policy of releasing terrorists from Guantanamo Bay or perhaps releasing criminals on our streets. And while I'm sure the leadership would be flattered, they'd be the first to say we still have a lot of work to do. He also mentioned that your job needs to be done humanely. You know, and we've talked about before, we have a huge gang problem in the country. It's a growing problem. And in fact, if we took gang members in the United States today, they would equal the 6th largest army in the world. So my question to you is this: is it humane to leave individuals who are here illegally and who have been active participants in a criminal street gang or who intentionally participated in an organized criminal gang to remain in the United States?
Such an individual is among my top priorities for removal, sir.
Good. If that's the case, and that is indeed the memo that you mentioned, we had a little difficulty because 3 months ago, your Director of ICE, Sarah Saldana, did not have a clue when she was asked, and you can look at the testimony and the record, when we asked her how many criminal aliens with violent gangs has ICE and or CBP processed and deported since DHS updated its policies, the policies you referenced. How many has ICE or CBP released? And third, what type of process is DHS using to determine who is a member of a criminal gang? So my first question to you is, can you give us today the number of criminal aliens with violent gang ties that ICE and or CBP has processed and deported since your policy was updated?
Well, that is a knowable number, which we can get to you for the record. Sitting here right now, I don't know the number, but it is a knowable number.
And here's the problem we have. This is one of your top priorities. The director said she didn't have a clue. And today, when we have a hearing to look at this, we don't have that number, so if you would get it back to us. But I would assume then that you also don't know how many ICE or CBP has released.
Again, it's a knowable number, sir. I just did not come prepared with the number. If I could have anticipated your question, I would have.
I would have just thought if it was one of your top priorities, that might have been a metric you would look to see if it was working. So let me ask you this
It
third one,
absolutely is one of my top priorities, sir.
but you just don't know whether it's working or not.
Like I said, it is a knowable number. I just don't have it with me.
But
among
you
all
don't know the knowable number.
I do know this. I have mandated, as part of that same directive, that we track who we remove.
Can I ask you this, because I don't have but 5 minutes. What type of process are you using to doing that tracking that you've mandated? How do you know who is a member of a criminal gang? Do you ask them?
Well, in fact, we have tightened up the guidance so that it is more, if we can more effectively identify.
Share with us, if you would, as a committee, how you've tightened it up. Do you ask the individuals if they are members of violent criminal gangs?
Well, if you're referring to applicants for deferred action, the answer is yes.
So your testimony today is that you ask every member who was an applicant whether they're a member of a violent criminal gang, because that would be in conflict with what the director said. So that is your testimony today.
My understanding is that when...
No, let me just make sure. You're saying it is the policy, you're sure of that, or you don't know what the policy is?
I know that being a member of a criminal street gang is certainly a disqualifier.
I understand that, but if we don't know who they are, it doesn't help us. Can you state under oath today that you know that each one of those applicants are asked whether they're even a member of a violent criminal gang?
I believe the answer is yes, sir.
You believe it is, but you do not know.
Well,
Can you
like I said,
confirm that and get it back to us for the record?
yes.
Do you know whether or not they're reviewing their criminal records, their trial records?
I'm sorry, what's the question?
Do you know whether the applicant's trial records are reviewed before a decision is made as to whether or not they will be released?
A trial record?
Yes, sir.
What's a trial record?
Trial record would be when they are going to court and they are prosecuted for a crime, there would be a record of that. And the reason it's important is because oftentimes it doesn't say on their conviction that they were a member of a violent criminal gang. Unless you're reviewing the records, you wouldn't have any way of knowing. I know, Mr. Chairman, my time is up. But
I know what a criminal record is. I don't know if I've ever heard the term trial record.
Well, let's use your word then as criminal record if you want to. But the problem with the criminal record is it doesn't always show all the details that was in the trial. And if you don't know that, you won't know whether when they plead they were actually a member of a violent criminal gang or not. Mr. Chairman, with that, I yield back. Very concerning that you have a major priority and we don't even know the metrics as to whether or not it's working or not.
Well, that would
Thank
be
you,
a
Mr. Chairman.
mischaracterization of what I said, sir.
The time of the gentleman has expired, and the chair recognizes the gentleman from Texas, Ms. Jackson Lee, for 5 minutes.
Let me thank you very much, Secretary. Thank you for your testimony. To my colleagues, I think I've said this before, that I have sat on the Homeland Security Committee since 9/11, the tragedy of 9/11. I think it is important to note that Secretary Johnson has made incredible advances in securing this nation. And I always say when we were apt to criticize the Transportation Security Administration and other agencies within Homeland Security, that we have faced challenges, but America has been made safer and more secure with the creation of this department. In particular, let me thank Secretary Johnson for noting the decrease in the surge of unaccompanied children, but as well, when a group of us went to visit Kearns and Dilley in San Antonio and viewed circumstances that were unacceptable to us, viewing children and mothers, that the department was responsive. And we appreciate the decrease in population legally of mothers and children dealing with the unaccompanied circumstances. I think it is important to take note that this is a huge challenge in securing this nation. And so allow me to quickly, and Mr. Secretary, if you just say yes or no on the reasons, because I want to get to my real questions, but I just want to say the PEP program that you have announced, would that have been a sizable intervention for the Sheriff's Department and other sanctuary cities to be able to respond to a circumstance like Mr. Sanchez? Does this give them a greater latitude and remain their sanctuary
Yes.
city status?
Yes.
And let me just say for my colleagues, a sanctuary city is not a choosing of the Secretary of Homeland Security. It is states' rights. It is individual cities making their determination. I would offer to say and ask unanimous consent to put into the record, and might I do this to my colleagues know with my deepest sympathy to that family, and I personally apologize to the family for this tragedy that has occurred in San Francisco. None of us would want to counter that or to support that or to be supporters of comprehensive immigration reform and support that violent act. But I do think it's important to note that murders in San Francisco, for example, compared to cities of Minneapolis and Dallas of the same size, those murders are at 5.75, and Minneapolis is 15.17 and 11.39. Over the years, the homicides in San Francisco has gone down. I don't necessarily want to condemn sanctuary cities, but I do want to condemn the idea of communication. And I want to join with Mayor Ed Lee, who said, could somebody simply pick up the phone? I'm looking at a order of activities here, and I see that ICE sent a detainer on 3/27/2015. And my question to the law enforcement of that city, it would not negate the sanctuary city authority to have simply picked up the phone and called ICE to be able to say this individual who has a long criminal history is in our facilities. Mr. Secretary, was that a possibility? In light of this horrible tragedy that we don't diminish, could that have been a phone conversation to ICE at that time from the Sheriff's Department and not violate their sanctuary city rules, per se?
Well, my strong intent with the new PEP program is that we have the type of cooperative relationship with local law enforcement such that we get notification before somebody is released.
Right, but
So
they
that
could
we
have
get
also-
there in time to pick them up when they are released.
And they could have also made a call at that time as well.
Yes.
I won't get into warrants and orders, but they could have made a call. Let me move quickly to this issue of violent extremism and just cite for you an article from the New York Times that made it clear that since 9/11, there were 19 non-Muslim extremist attacks versus 7 Islamic militants attacks, and we all know that we're concerned about ISIL and a cell in every state. But I am concerned as well about Homeland Security looking at violent extremism that are dealing with anti-government feeling or racist feelings. I have every respect for opinion and speech that expresses hatred toward me because I'm an African American, but not violence, as evidenced by Mother Emanuel. Can you explain what you will be doing about capturing those who engage in violent, anti-extreme, anti-government activities, and of course, racial violence that is rising as a perspective of domestic terrorism?
Well, of course, there's always the law enforcement approach to hate crime, to violence. Our CVE and efforts across the department should be comprehensive, in my view. I have personally spent a lot of time on CVE engagements, as you know. We attended one together in Houston about a month ago. At the moment, my priority has been focusing on communities that I believe are most vulnerable, at least some members of the community, to appeals from ISIL, Al-Qaeda, and other terrorist groups overseas who are actively targeting individuals in these communities. And so I think we need to focus on communities that themselves have the ability to influence somebody who may be turning in the direction of violence. Without a doubt, there is the potential, the very real potential, of domestic acts of terrorism. I just went to Oklahoma City for the 20th anniversary of the bombing there in April. A program that counters domestic violent extremism, domestic-based violent extremism, is, in my judgment, a little more complicated. terrorist threat to the homeland from overseas that I'm concerned about is one that is making active efforts to recruit people in response to ISIL's recruitment efforts. And so we've been, as you know, very focused on that. But I do agree with the spirit of your question that violent extremism in this country can exist in a lot of different forms, ma'am.
Let me thank you. Mr. Chairman, may I ask unanimous consent to include these two documents in the record? And may I just put one sentence on the record? I thank you for your indulgence. Is, Mr. Secretary, I implore you to consider domestic terrorism, and I'd like to work with the department to seriously add that to its broad agenda. I think it would be a vital and important step forward. And let me thank you for your service.
The time of the gentleman has expired. That's a long run-on sentence, but we will allow it. And those two documents will be made a part of the record, and the chair now recognizes the gentleman from Iowa, Mr. King.
Thank you, Mr. Chairman. I appreciate this hearing, Mr. Secretary. I appreciate also your testimony here. Listening to the testimony, yeah, there we go. Listening to testimony about ICE detainers, and I'm going to pause for a minute here. Can I have a clear path? Thank you. Listening for the moment about ICE detainers, this first question occurs to me, and that is that how long have we been operating under ICE detainers when they were mandatory? Do you know when their inception was?
ICE detainers
Yes.
go back a long way. They go
96?
back to when I was a federal prosecutor 25 years ago, we had immigration detainers.
Okay, so they were mandatory for a long time. And how long has this been a problem? In your testimony, you said that in the last year, 12,000 ICE detainers were ignored or not responded to by local law enforcement. 12,000. Is that indicative of a problem we've had over a 20-year period of time, or is that a short-term anomaly?
I think that that number has been growing with the number of jurisdictions that have been passing ordinances and laws and signing executive orders that limited their ability to cooperate with us. So I suspect the number has been growing annually, sir.
Would it be perhaps in sync with a 2012 ACLU, quote, fact sheet that was sent to local law enforcement nationwide that said that ICE detainers are not mandatory because no penalty existed? And they have this legal rationale reach of if there is no penalty, then there is no law to be enforced. Are you familiar with that?
I'm not familiar with that fact sheet, sir, no.
Okay, I would make sure you'll get a copy of that, so you are. But February 25th of 2014, so can you tell me if that's about the date that the number of local jurisdictions ignoring the detainers began to accelerate?
I do not know the answer to that question, sir.
But we do know that the department has cooperated to some degree with ICE, with ACLU. And I'm looking at a letter that was sent to a Congress member of this committee, dated February 25th, 2014, from U.S. Immigration, from ICE. It says, while immigration detainers are an important part of ICE's effort to remove criminal aliens who are in federal, state, and local custody, they are not mandatory as a matter of law. The Congress was informed February 25th that ICE and your department was going to back away from detainers. And I'm listening to an ICE spokesman tell the people trying to enforce the law in San Francisco that it's all their sanctuary city policy, not a policy that has to do with ICE's decisions. So I just raise this as a point that there are a whole series of jurisdictions that are culpable here. And I would ask, have you sat down, or do you have people in your department that have sat down and calculated the resources necessary to enforce all of the law? And I would express that in sync with Rudy Giuliani's policy, former policy in New York, the broken windows policy. We arrest people that break the law as quickly as we can and enforce the law so that there is an expectation that it's a deterrent. To get to that point, to restore the respect for immigration law, which has been damaged, perhaps I still believe we can repair it. What would the calculation be for the resources necessary to accomplish such a thing?
Congressman, you referred to restoring respect for immigration law.
Let's just call it full enforcement then, so
That's
I don't run out of
exactly
time.
what I'm trying to do with our new
And what
priority
resources do you
enforcement
need
program.
then to do that? You've got more beds than you're using. You've increased the number of officers. We've got significantly fewer arrests taking place. That doesn't convince me that there are fewer border crossings. I mean, if the order were issued to arrest half the people you were, that would be all that it would take to see those numbers go down. It's never been indicative to me of lower border crossings.
I'm glad you asked that question. What resources do we need? I would like to see our immigration enforcement personnel put on a pay scale with other law enforcement personnel. As you probably know, a lot of them are topped out at GS9. One of our executive actions was to have pay reform for immigration enforcement personnel.
Okay. I'm happy to take that conversation up, as I do believe that we ought to be as supportive as we can of especially the people that put their lives on the line. But they want to also do their job. And I want to make sure we have the foundation to get that done. And when you're asked the length of the fence, how long is the border, the southern border?
How long is the southern border?
Yes.
I believe it's 2,700 miles, sir.
Yes, I brought that up because I want to give you an opportunity to state that. It's actually very close to 2,000 miles. The estimates run just a little bit under that. But I bring this up because I think it's important for this committee and for you and the public to consider what we're doing. We're spending $13 billion on our southern border to secure our border. That's the 50-mile line. When you add everything up, I don't know anybody else that even tracks that number. That comes out to be a little less than $6.6 million a mile. Now, that might not be astonishing unless you think that about 25% of those that are attempting to cross the border actually are interdicted, and many of them are released again, maybe for 5 times. Actually, 27 times is the highest number that I see. We're building interstate highway across expensive Iowa cornfields for $4 million a mile. That's 2 fences, that's grading, paving, shouldering, and signage, and all the things necessary, plus archaeological and environmental. If we can build interstate highway for $4 million a mile, we could take a third of that budget down there. In a matter of 2 years, we'd have that whole thing, fence, a wall, and a fence. We would have patrol roads in between 2 no-man's land zones. And by the way, if we do that, these fences don't have prosecutorial discretion. They will be effective. The Israelis is up to at least 99-point-something% effective. They put $1.8 million a mile in theirs. They had 14,000 illegal crossings in one section. It cut it to 40. And so I think there's an economic equation that your department could bring forward, and I'd be very happy to sit down and go through the numbers. I spent my life in the contracting business, and I think that we could put a lot better application to these resources than are being used today. And I thank you for your testimony, and I yield back the balance of my time.
Time of the gentleman has expired. The gentleman from Tennessee, Mr. Cohen, is recognized for 5 minutes.
Thank you, Mr. Chair. And first, I'd like to recognize and say hello to our Mr. Johnson, who is from the other great city in Tennessee, which has the second best barbecue, but the greatest HBCU and one of the great in the country, in Fisk, where his father was actively involved. I want to follow up on Ms. Jackson-Lee's questions. And we need to be concerned about threats from afar and recruitment of our people from afar in ISIS. But the fact is, we've got more of a threat domestically to our lives than we do internationally. An article in the New York Times just this past year, June 16, just this past month, cites the fact that since 9/11, an average of 9 American Muslims per year have been involved in an average of 6 terrorism-related plots against targets in the U.S. Most were disrupted, but the 20 plots that were carried out accounted for 50 fatalities over the past 13 and a half years. In contrast, right-wing extremists averaged 337 attacks per year in the decade after 9/11, causing 254 fatalities, over 5 times as many as the Muslim-caused fatalities. This was according to a study by a professor at the United States Military Academy's Combating Terrorism Center, and that toll has increased since the study was released in 2012. So I ask you about our efforts to curtail domestic right-wing extremists. I believe that in 2011, there might have been a department that funding was cut or even abolished. And do you have any, is there any consideration that you've given to increasing funding and or renewing that department? I think that The Department of Homeland Security in 2009, the department disbanded the Extremism and Radicalization branch of the Homeland Environment Threat Analysis Division. Do you think it would be appropriate to have that division recreated or reinstated?
Congressman, if you don't mind, let me answer it this way. We fund over $2 billion a year in grants to state and local law enforcement for Homeland Security / public safety purposes of a lot of different stripes. So the first responder equipment that we fund is valuable, whether it's a terrorist attack, a mass shooting incident, motivated by whatever purpose. So, for example, the Boston Marathon attack, which is very definitely an act of terrorism, our first responders there were funded to a very large measure by my department, even though they were local. And so our grant money goes to a lot of valuable things to promote public safety. We have active shooter training, for example.
I understand that and appreciate that, sir, but what I'm asking about is the department had a department called the Extremism and Radicalization Branch of the Homeland Environmental Threat Analysis Division, and apparently that division was not reinstated. That's different than grants. That's something specifically looking at the internet and seeing if they can't ferret out some of these folks before they get their weapon and go to a church and commit a mass atrocity. Have you considered reinstating such a division in light of the fact that the statistics are overwhelming that they are continuing to threaten our people?
Well, I agree with the spirit of your question when it comes to the statistics. I would have to look into your specific question, sir.
I'd appreciate if you would. After Charleston, the Union of Orthodox Jewish Congregations of America noted that we need, as everybody I think would agree, freedom of worship. We need freedom from fear. Houses of worship need to be safe. The National Security Grant Program provides grants to communities to buy surveillance equipment and shatterproof windows. Much of that goes and has been going, and I'm pleased it has been going, to Jewish organizations and synagogues which have been targeted over the years with threats. But now that we see in the South in particular, and we've seen it over the years, but a rash recently of attacks on African American churches, can your department look into requesting an increase in funding so that it can cover African American churches that are also threatened in this day and time?
We can, sir. I just met with officials of the American Jewish Committee last week, who were very complimentary of the relationship that we have with the Jewish community in this regard. As I think I mentioned to you, Congressman, my great-grandfather was a Baptist preacher in Southwest Virginia near Roanoke, a little town on the Virginia-Tennessee line called Bristol. And back in the turn of the century, 115 years ago, a lot of that, being a Baptist preacher in that part of the world meant breaking up the occasional lynching attempt. So I appreciate the importance of your question, sir.
And I appreciate your service. Thank you, sir. I yield back.
Chair thanks the gentleman and recognizes the gentleman from Arizona, Mr. King, for 5 minutes. I mean, Mr. Franks for 5 minutes.
You've insulted both of us, Mr. Chairman. Thank you, sir. Secretary Johnson, a report from the National Academy of Sciences places, quote, an estimate of $1 to $2 trillion during the first year alone for the societal and economic costs of a severe geomagnetic storm scenario, with recovery times of 4 to 10 years. Another report from Lloyd's of London stated that between 20 and 40 million people in America are at risk of extended outages for up to 1 to 2 years in duration. And I can read excerpts of 11 major government reports that all share very similar findings for ours here, as you know. And yet the federal government has really done next to nothing to help protect the electric grid. And so I just would remind you that last year you testified that it was the main responsibility of the National Programs and Protections Directorate, or the NPPD, within Department of Homeland Security, along with other, of course, relevant agencies, to protect the electric grid. And so I'd like to ask you what is being done today at DHS to protect the grid from geomagnetic disturbance or from weaponized electromagnetic pulse, and do you support legislative efforts like the Critical Infrastructure Protection Act that has now come out of the Homeland Security Committee to actually focus on this threat and act upon it?
In general, sir, I'm very supportive of the efforts being made. I know that the threat that you mentioned is one that we study and evaluate. I'm happy to get back to you more specifically for the record in answer to what detailed steps we are taking and how we regard this particular threat, sir.
Well, I appreciate that. I hope that you would take a special look at the Critical Infrastructure Protection Act. It's going to be entirely within your purview to respond to it, and I think it's something you'll probably support. I sort of changed the subject there, but I have to get back to the subject now of the Constitution. I have the privilege here of chairing the Constitution Subcommittee, and so that's part of the predicate. Article 1, Section 8, Clause 4 of the Constitution provides that the Congress shall have power to, quote, establish an uniform rule of naturalization, and grants Congress plenary power over immigration policies. That's very, very, very clear. Aren't your administrative actions and your agency's administrative actions to exempt millions of unlawful and criminal aliens from any threat of enforcement of our immigration laws a usurpation of Congress's constitutional role?
Inherent in the enforcement of any law, sir, is the exercise of prosecutorial discretion. And that's what we do in the enforcement of our laws. That's what the Department of Justice does, and that's what multiple other agencies do.
Well, in all due deference to you, prosecutorial discretion is one thing. The suspension of the law is another. And I will probably leave it right there, Mr. Chairman.
Chair thanks, gentlemen. Recognize the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. This is a hearing where Republicans are arguing that the administration is not enforcing the immigration laws and that this is leading to increased crime. Exhibit A, the murder of Ms. Steinle in San Francisco. And that event happened within the last 2 weeks. And I am really impressed with the speed by which this committee has sprung into action to bring this issue before a hearing. You know, I mean, and then going to take advantage of it for political purposes is basically what's happening. However, something like the flying of Confederate battle flags in national park spaces, something that is salient, germane, and current, they want to put that off to a committee for a study or for a hearing that will never be held. So it's politics, what we're playing up here, Secretary Johnson. I appreciate your service, by the way. What we have is a situation where Ms. Steinle was allegedly murdered by Mr. Juan Francisco Lopez Sanchez, who had been in federal custody for about 6 years on an illegal, on a felony illegal entry into the U.S. ICE had a hold on him so that when he was released from the Bureau of Prisons, he would go into ICE custody for deportation again. However, ICE also has a policy that when a local jurisdiction has an active warrant against an individual, then ICE yields to that local authority holding that warrant. And that local authority, San Francisco County in this case, decided to pursue its warrant. So it took custody of Mr. Sanchez, Mr. Lopez Sanchez, and after they took custody of him, ICE had a warrant or a detainer lodged against Mr. Lopez Sanchez, so that when San Francisco finished its prosecution, then it would turn Mr. Lopez Sanchez back over to ICE for deportation. And then what happened was after Mr. Lopez Sanchez was in the custody of San Francisco County, the authorities there decided not to prosecute him, and which meant that he was eligible for release. And ideally, it would have been to ICE, which had the detainer in place. However, due to its local politics, San Francisco County had a situation, a sanctuary policy, where they did not honor those warrants. And so it was not, so I go through that to say that it was not the fault of ICE, or it was not a breakdown in federal immigration enforcement that resulted in Catherine Steinle's murder allegedly by Mr. Lopez Sanchez. It was not the fault of your department, although they're trying to make it appear to be that way. And in fact, under this president, there have been, this president is now known as the deporter-in-chief. Why is that, Mr. Johnson? Is it because over 2 million people have been deported under his presidency, which is more than were deported under the previous administration in 8 years, with 17 months left on this term? Is that the reason why he's known as the deporter-in-chief?
Well, let me answer your question. Let me say two things, sir. One, as I have mentioned, I believe it is important that we focus our deportation resources on threats to public safety. And with our new policy, I believe we are doing that increasingly so. A higher percentage of those in immigration detention today than used to be the case are those who are in my top two priorities for removal. 76% of those in immigration detention today are in my top priority for removal, the felons, those apprehended at the border. So I want to focus our resources on threats to public safety, and I know the President supports that and he shares that view. The other thing I'll say in response to your question, sir, is, as I mentioned earlier, I think we need to evaluate carefully whether it is appropriate in every case for a criminal warrant to be a priority over an immigration detainer. It may not be. There may need to be some additional flexibility and discretion built into that. So I want to evaluate any such policy.
Thank you. And I yield back.
Gentleman yields back. The chair would now recognize the gentleman from Ohio, Mr. Jordan.
Thank the Chairman. Secretary Johnson, on November 20th, 2014, the President issued his now somewhat famous executive order. You did a memo regarding DACA and deferred action. You recall all that, Mr. Johnson?
Yes, sir.
All right. And then February 16th of this year, Judge Hainan has a ruling that blocks the action of the President and the action outlined in your memo, correct?
Yes, sir.
And during the hearing in front of Mr. Hainan, Judge Hainan's court, January 15, 2015, your counsel represented to the court, quote, no applications for revised DACA would be accepted until the 18th of February 2015. Is that correct, Mr. Johnson?
I don't know exactly what the colloquy was, sir.
Okay, this is from your counsel and from the court. But regardless of what it was, the representation that no applications would be for revised DACA would be accepted until the 18th of February, that turned out to be wrong. Is that accurate, Mr. Johnson?
Well, in fact,
That representation that was made in front of the court was not accurate.
like I said, I don't know the exact colloquy. I do know that in November, we began issuing 3-year renewals consistent with the policy. It was on the face of the policy, and it was in the...
Well, let me read what Judge Hainan said, because your counsel actually filed an advisory with the court clarifying, saying that even though you said you would not accept applications and they would not be revised, they in fact were up to 100,000. And here's what the advisory, you advised the court, and here's what the judge said. The court expects all parties, including the government of the United States, to act in a forthright manner and not hide behind deceptive representations and half-truths. That is why the court is extremely troubled by the multiple representations made by the government's counsel, both in writing and orally, that no action would be taken pursuant to the 2014 DHS directive until February 18, 2015. So here's what I want to understand. You said you weren't going to issue, but you had already issued 100,000 3-year deferrals. You had to go tell the court, oh, what we told you in the earlier hearing wasn't in fact true. When did you know, as the head of this agency, the head of this department, that the representation made to Judge Hainan and to the court was in fact not accurate?
Well, I definitely know that this is an issue for the judge, that he is very troubled about.
That's not my question. When did you know what you had told the court, your counsel had told the court, when did you personally know, as the head of the agency, that it wasn't accurate? Did you know when they said it? Did you know clear back in January when they had the hearing that what they were conveying to the court wasn't true?
No, I did not know when they said it because I was not...
Okay, so when did you learn?
Sometime shortly, I don't have the exact time frame, but sometime in early March, I became aware that this was an issue. And
who told you?
Wanted to, I don't recall, sir, and wanted to be sure that we promptly advised the court of this issue, and we did. I will say also that the fact that we began issuing 3-year renewals was on the face of the policy, which was in the record of the court. I know this is an issue. I know the judge is troubled by it, but...
He's not troubled by it. He said it was half-truths, deceptive representation. He's extremely troubled by it, and that's his words, not mine. So when a judge says that you falsely represented something in front of the court, you later learn you did that, according to what you just told me, and then you convey it to them. I want to know when exactly you learned and how long after you learned did you convey it to the court? Do you know that?
I've already answered that question.
No, but when you learned, did you convey it that very day? Did you wait a couple days? When did you convey it?
I don't know how many days it was. Could have been same day, could have been 2 days. I don't know, sir.
Do you know what day you happened to advise the court that you, in fact, had misrepresented the facts to the court? Do you know what day you had sent that advisory? Do you know that date?
I don't know when the advisory was filed. I do.
March 3rd, 2015.
I was going to say, I do know that it was in early March.
Okay, do you know what else happened on March 3rd, 2015?
A lot of things, sir.
Well, relative to your agency, you know what happened that day?
Refresh my recollection.
Same day that we were having a little debate in Congress about the funding bill for your agency.
That is
so the same day that the DHS funding bill passes Congress is the same day you decide to tell the court, oh, by the way, we lied to you back when we didn't give you all the facts earlier on. Now, don't you think it would have been nice if the Congress, during that heated debate, in fact, I remember you, Secretary, you were on TV that entire weekend, that March 1st, March 2nd, that entire weekend, you were talking about if this bill doesn't get done, if we don't get funding, hang on, sky's going to fall world. It'd have been nice if you'd have also told the Congress and the American people, oh, by the way, we misrepresented the facts to the court dealing with this issue. But you send the advisory the same day that we passed the bill. It'd be nice if we'd have had that information before the date we actually voted on this and went on record.
There are so many things wrong with that question. I do not have 37 seconds to answer it.
Well, let me just, Mr. Chairman, if I could real quick. March 3rd, you filed the advisory, right? March 3rd, you filed the advisory. March 3rd, the DHS bill passes. Those are two facts. That's just a coincidence?
Gentleman's out of time, but I'm going to allow the Secretary to answer the question.
First of all, my recollection is that I was on the Sunday shows earlier in the month of February, so that doesn't work, okay? Second,
That's why I'd like to know when you found out.
I don't recall when exactly in the course of the day, sir, the funding bill was passed, and I really don't think one has anything to do with the other. I knew this was an issue. I found out about it in early March, and I wanted the court to be
It was important enough to advise the court. It might have been important enough to let Congress know in the heat of that debate, when this is the central issue of that debate, that, oh, by the way, our counsel didn't represent the facts to the court like they should have. That's an important element for this body, the Congress of the United States and the American people to know in the course of that fundamental debate we were having. And you don't think it's important to know that?
The gentleman really is out of time this time, and I'm going to allow you to respond, and then I need to go to Ms. Chu from California.
I do not believe one has anything to do with the other. I do not recall whether Congress voted for our funding on March 3rd or March 4th. I tend to think, but I don't have the calendar in front of me, that it was on March 4th. So that is my recollection. I was intensely interested, obviously, in the debate going on in this Congress about funding our department so that I wasn't going to have to furlough a whole lot of people. So my recollection is that it passed the Congress on March 4th, but I could be wrong. But I don't have the calendar in front of me.
The gentleman from Ohio yields back. The chair will now recognize the gentlelady from California, Ms. Chu.
Yes, Secretary Johnson, I was one of the 8 Congress members that visited the Dilly and Carnes Family Detention Center, and I was horrified by the situation. And I thank you for reevaluating DHS's family detention policy and your announcement yesterday that ICE will generally not detain families if they've received a positive finding for credible or reasonable fear. It's a huge step forward, and I hope it'll bring our policies in line with our international obligation to protect those that are fleeing persecution. The families that I spoke with when I was there were not criminals. They were victims escaping extreme violence. I heard from a mother from Honduras whose son and daughter were forced into the drug cartels. She was raped, as well as her 15-year-old daughter. She and her daughter escaped but ended up in the detention facilities for months. The mother had a credible fear determination, but then she was given a $10,000 bond obligation, which made her desperate because she couldn't afford it, and it might as well have been $1 million because it was unattainable. And then her daughter, in reaction to the desperation, had to be taken to the medical unit for wanting to commit suicide. It's my hope that DHS's new policy means that families like these will no longer be detained and no longer subject to such unreasonable bonds. So, Secretary Johnson, could you describe how the agency will implement this new policy, and how long do you expect the review to take?
Well, much of the reforms that we announced and that I directed are underway already. In terms of the review of the cases, the older cases, that review has already been undertaken, and it has produced results. In terms of the new bond policy, I believe also that policy has in fact been implemented and is underway. The review that Director Saldana directed of the facilities themselves, the advisory committee, I would have to get back to you in terms of the exact status of that.
In fact,
thank you also for visiting the facility, and thank you for meeting with me after you did so.
Thank you. In fact, I wanted to get more clarity on the bonds for the families. Will ICE continue using bonds for these families? And how will you work to ensure that these bonds remain reasonable for them?
Well, I've directed that they be realistic and be reasonable, and I have asked that I receive regular reports on what the bond levels are, and I know that ICE is developing, if they haven't already developed, criteria for setting bonds at a consistent and affordable rate. When I was at one of these facilities, I was struck by the number of people who were there who had a bond set, but they were not able to produce the cash. And so this is one of the things that I want to be sure we set at a realistic rate.
I also wanted to ask about a different detention center. That's Adelanto Detention Center in California. There have been numerous reports documenting inadequate care for the detainees. This facility is run by a private company, Geo Group, and we know that Geo's failure to provide adequate medical care resulted in the death of at least one detainee, Mr. Fernando Dominguez, who was detained for 5 years and died of intestinal cancer several days after he was rushed to the hospital with unusual bleeding. Now, this facility has recently been expanded by 640 beds, and it's of concern considering the history of medical neglect. So, Mr. Secretary, what is ICE doing to ensure that the private companies that it contracts with provides adequate medical care and abides by the ICE performance-based national detention standards?
This is a priority of mine. It's a focus of mine, and I believe it is a priority and a focus of Director Saldana. I've heard concerns raised about private contractors running detention facilities, and I want to be sure that we get this right, both with respect to the conditions and with respect to clarity about lines of authority and responsibility. So when you have a private contractor in the mix, whose responsibility is it day to day to ensure the conditions of confinement? And so it's something that we're looking into, and it's something I'm very interested in.
Thank you. And I yield back.
Gentlelady yields back. The chair will now recognize the gentleman from Pennsylvania, former U.S. Attorney Mr. Marino.
Thank you, Chairman. Good afternoon.
Good afternoon.
Mr. Secretary, I first, as a former U.S. Attorney, realized the complications involved with dealing all kinds of local law enforcement entities. It can be quite chaotic. However, I am disappointed with the administration in the way it is not, I think, directly handling sanctuary cities. I think the administration can have a much more direct impact by being aggressive, as it has in other areas, to force sanctuary cities to be in contact with ICE. I've worked with ICE for a great deal of time. I think they're some of the best agents that we have in the federal system. And I do agree with your position on the pay. But I put most of the blame on sanctuary cities at this point. But however, I put part of the blame on Homeland because of the void between a detainer and a warrant. And I know in some situations a warrant may not be applicable, but give me some insight on how you see or what directive you can give to sanctuary cities in particular of letting ICE know when an illegal individual, an illegal person that is in this country is being released from any facility. Do you have anything on mind at this point?
Well, if it's somebody that we want for detention purposes, for removal purposes, my hope is that they not be released, period. I honestly believe the most effective way to go about getting at undocumented criminals in local jails is through a cooperative, constructive effort.
But I'm sorry to interrupt, I only have a little bit, but that isn't working. So I think you have the authority. I think that you need to take the tough position to say, hand out a directive, you will respond to us, and if you need something done legislatively, come back to us. With all due respect, sir, I think that the administration is avoiding this because of its propensity to want amnesty the way that it does, but that's a matter for another day. But if you want to respond to that,
The problem, if I may, is for a long time, we did take the position that detainers were mandatory. And that was leading to a lot of litigation in the courts.
Right, I'm aware of that, sir.
We're losing.
Yeah.
We're losing for reasons of the due process clause of the Constitution.
So maybe you need us to help out a little bit.
Frankly, we were losing with a lot of these jurisdictions who were passing all these laws saying, thou shalt not cooperate with ICE.
I understand that.
And that led to a real public safety problem, in my view, which I think we are correcting now.
Well, if any time you think that you need the legislation to help you in that direction, please contact us. I want to switch to another situation here, particularly in my district, but it's happening across the U.S. Last year, the U.S. Sentencing Commission promulgated an amendment to the federal sentencing guidelines, Amendment 782, which reduced the base offense level for all drug trafficking by 2 levels. The amendment was also made retroactive, and as a result, more than 10,000 drug trafficking offenders will be released early from prison beginning on November 1st of this year. And I have in front of me, this pertains to the Middle District. There'll be 68 people released between November 1st, 2015 and December 31st, 2016, and many more after 2016. And as the state gets closer to the border, those numbers increase, because on my list of 68 people, there are about 20%, 19 of them are from outside the country. Now, this list doesn't tell me whether they're illegals or not, but I would ask if you could take a look at this, pay attention to particularly the list of people that are from outside the country to see if they are violent illegals. And that's probably another way that we could stop a great deal of what has been taking place, particularly what has happened over the last 2 weeks, and my condolences do go out to that family. Would you please respond?
Yes, I'm aware of this issue. I'm aware of the adjustment to the federal sentencing guidelines. I'm aware that a number of individuals will be released as a result. I'm aware that a number of them are probably undocumented, and we've been working with DOJ to do the most effective thing for public safety in that regard, and we will continue to do so, sir.
I appreciate that, and I yield back the 1 second of my time.
Gentleman yields back. The chair will now recognize former Attorney General from Puerto Rico, Mr. Pierluisi.
Thank you, Chairman. Secretary Johnson, welcome back to the committee.
Thank you.
When you testified here last May, we spoke about drug-related violence in Puerto Rico. The same subject I raise with virtually every senior DHS and DOJ official that comes before this committee. Like I did then, I want to outline a narrative for you and ask you to comment. I will be brief so you have sufficient time to respond. In 2011, there were 1,136 homicides in Puerto Rico, an average of over 3 a day, the most violent year in the territory's history. That was nearly the same number of murders as were committed that year in Texas, which has over 25 million residents compared to 3.5 million in Puerto Rico. Most murders in Puerto Rico are linked to the drug trade, since Puerto Rico is within the U.S. Customs Zone and is used by organizations transporting narcotics from South America to the U.S. mainland. When I examined the level of resources that DHS and DOJ were dedicating to combat drug-related violence in Puerto Rico, it was clear that the federal law enforcement footprint on the island was woefully inadequate. Accordingly, I did everything within my power to change that dynamic. Starting in 2012, under your predecessor, Secretary Napolitano, the message finally began to sink in. DHS component agencies like the Coast Guard, ICE, CBP started to step up their games. The Coast Guard has massively increased the number of hours that its ships and planes spend conducting counter-drug patrols around Puerto Rico. ICE surged its agents to Puerto Rico, where they arrested hundreds of violent criminals and seized vast quantities of illegal drugs and firearms. CBP assumed control of the Aerostat program from the Air Force and moved quickly to repair the radar in southern Puerto Rico that had been inoperative since 2011. The actions taken by DHS, in conjunction with its federal and local partners, have made a major difference in a very short period of time. Each year, the murder rate has declined. In 2014, there were 681 homicides in Puerto Rico. That is 40% lower than 2011. In 2015, to date, there have been 287 homicides. If current trends continue, there will be half as many murders this year as there were in 2011. I am not sure if there's any other jurisdiction in the world that has experienced such a steep and rapid crime drop. It is critical that we keep our eye on the ball and that we sustain and strengthen these efforts, especially since, notwithstanding the improvements, Puerto Rico's homicide rate is still 4 times the national average. Rest assured that I will continue to do my part. As you know, the Coast Guard is modernizing its fleet of vessels in Puerto Rico, replacing our 6 older vessels with 6 modern vessels. Last week, I met with Peter Etch, the Executive Associate Director of ICE, HSI, which is doing great work in Puerto Rico to discuss the agency's current posture and future plans on the island. On the legislative front, I secured language in the DHS appropriations bill that will enable CBP to use both revenues from the Puerto Rico Trust Fund and general appropriations from Congress to support its air and marine operations in the territory. I would welcome any comments you might have and hope you can assure me that Puerto Rico will continue to be a top priority for DHS. Thank you.
The answer is yes, and since we last met last year, we have created and operationalized my Southern Border Campaign strategy, which brings to bear all of the resources of my department in different regions in a coordinated fashion. We're doing away with the stovepipes. So we have a joint task forces east, for example, which is for the southeast part of the country and the maritime approaches, where we now have, in a combined and coordinated way, all of the border security law enforcement assets of my department devoted toward the southeast. And so we now have the Coast Guard, CBP, ICE, CIS working together in a coordinated fashion for public safety and border security. And I think that's a very positive step, and I think it will be a positive step for Puerto Rico as well.
Thank you so much.
Gentleman from Puerto Rico yields back. The chair will now recognize the gentleman from Texas, former chairman of the committee, Mr. Smith.
Thank you, Mr. Chairman. Secretary Johnson, I'd like to go to the 30,000 convicted criminal aliens the administration released last year. It was 36,000 the year before. It's been over 30,000 for the last several years. Arguably, about 2,000 of the 30,000 had to be released because of the Zavitas Supreme Court case, but that left 28,000 that I don't believe needed to be released. A partial breakdown of the 28,000 convicted criminal aliens the administration released and didn't have to include 5,000 convicted of dangerous drugs, 500 convicted of stolen vehicle, 200 convicted of sexual assault, 60 convicted of homicide, over 300 convicted of commercialized sexual offenses, and over 100 convicted of kidnapping. Why did the administration release them, and is the administration going to continue to release these types of individuals?
Congressman, as you and I have discussed previously, I'd like to see that number greatly reduced to the extent legally possible. And so last year, ICE, at my encouragement and direction, issued new policies to tighten up on the situation where somebody who has been convicted of a crime and who has served their sentence and transferred to immigration is then released.
Okay.
And so we have a higher level of approval for doing so. We should not release people for lack of space or budgetary concerns.
Do you expect this number to come down dramatically in the next year?
I would very much hope and like to see it come down in
That's
fiscal year.
pretty much up to the administration whether it continues to release individuals back into our communities. And as you know, many of them are convicted of additional crimes, which I think could have been avoided. Doesn't sound like you disagree with me.
Well, like I say, I want to see that number come down dramatically. As you point out, there is the Supreme Court decision, which constrains our discretion somewhat.
Right. That only applies to about 8%.
But like I said, and also a lot of it is up to the immigration judges, but I want to see this number come down.
Okay. I hope that you can succeed. That number has been 30,000 or over for the last several years, and I haven't seen any improvement. A 1996 bill that I happened to have introduced became law, and a part of that law mandated that local officials cooperate with federal immigration officials. Do you feel that San Francisco and other sanctuary cities are violating current federal law?
I don't have a judgment with regard to that, sir. I do believe that the most effective approach is a cooperative.
Well, I know. I heard you say that a while ago. You have no opinion as to whether you think sanctuary cities are violating current federal law, which I'm assuming you're familiar with.
I do not have a legal judgment on that question, sir.
Okay, I'm appalled that you don't. One fact is that under this administration, the number of sanctuary cities has been increasing dramatically. Has the administration done anything to discourage a city from becoming a sanctuary city?
Absolutely, every day. We are with the new...
No, all these new sanctuary cities where you have city
I-
councils who have voted to become sanctuary cities, has the administration tried to discourage
personally,
any of them?
along with other senior officials of this department, engaging mayors, governors, county supervisors, city council members about cooperating with us pursuant to the new...
No, not
program.
cooperating.
So
I'm
the
asking
answer
you
is
if you
yes,
I'm asking you if you discouraged any city from becoming a sanctuary city.
I am encouraging people to cooperate.
So the answer is no, you have not tried to discourage
the
any
answer is
city.
yes.
No, you say you're encouraging cooperation. That's after they become a sanctuary city. I'm asking you, did you discourage any city from trying to become a sanctuary city?
Well, look, there are 300...
That's pretty critical if
There
you're
are-
not doing anything to discourage cities from becoming a
There are
sanctuary.
now, irrespective of what label you put on it, there are now 300 jurisdictions that have, to one degree or another, erected limitations on their ability to cooperate with us.
And did you do
I
anything to
find
prevent any of those?
unwind
Did you
that
do anything to prevent any of those
as
300
possible
cities?
For the sake of public safety.
Mr. Secretary, did you do anything to prevent any of those cities from becoming a sanctuary city?
A lot of jurisdictions I meet with probably regard themselves as sanctuary cities. I don't know that...
I think it's
there is a
clear
magic
you
phrase
don't want to
for that
admit it, but I
definition.
think it's clear you did not try to discourage any city from becoming a sanctuary city. One more question. The President said in regard to the surge last summer of illegal immigrants, particularly those coming from Central America, that they were going to be sent home. It's my understanding that roughly 92% are still in the United States. Why hasn't the President kept his promise to return those individuals home?
When you're talking about children, I think that's what you're asking.
Not entirely, but regardless of how you wanted to label them, the President said that they would be returned home.
Inevitably, removal and repatriation of a family or a child from Central America becomes a time-consuming process because, as I'm sure you know, they very often are
Do
searching
you agree
for
with my
claims.
statistic that 92% roughly are still in the United States of the individuals the President said were going to be returned home?
I haven't heard it put that way before, so I don't know. I do know that an awful lot of them are still here in deportation.
I think it's 92% contrary to the President's pledge to the American people. I yield back, Mr. Chairman.
Gentleman from Texas yields back. The chair will now recognize his friend from Illinois, Mr. Gutierrez.
Welcome, Mr. Secretary. Happy to have you back here before this committee. First of all, I think the gentleman just misspeak on the issue. Not all jurisdictions call themselves sanctuary cities. It's a political term of art. Some people appropriate and others don't. But it is clear that a federal district court in Oregon ruled that a county violated a person's Fourth Amendment right to be free from unreasonable seizure by keeping the person in custody based on nothing more than an ICE detainer. Now, that's a federal court that made that determination, not the Secretary of Homeland Security. A federal circuit court, the Third Circuit, ruled that because ICE detainers are not mandatory but voluntary, with all due respect to the gentleman from Texas and the law that he passed in 1996. That's what a federal court said in the Third Circuit. Voluntary law enforcement agents are free to disregard them. And that is exactly what we're doing. So instead of having the Secretary of Homeland Security here asking him, well, how many people have you tried to dissuade? The federal courts have said that the detainers are a violation and are not enforceable, regardless of what we here believe they are. And so why don't you just haul in the mayor of San Francisco and then haul in the mayor of Chicago and haul in the mayor of New York and just 300 jurisdictions and bring them before him? What are you going to do, lock them up too? Because they don't abide by the way you look at the world and how things should be enforced? These are local jurisdictions that have made a decision that as they carry out local police enforcement, which is a local issue, this is the way they want to do it. And that they're not going to cooperate. Now, what we can do, instead of having this hearing here, which will lead to absolutely nothing, unfortunately, Mr. Chairman, this will lead to nothing. This will not lead to a solution. Everybody will feel better. They'll get a few headlines. They'll put something on their Facebook, and they'll say, well, we put in a day's work. But it'll lead to nothing. Why don't we get to the business of making sure? Mr. Secretary, I'd like to ask you a question. Of the 11 million or so undocumented immigrants, did all of them cross the border between Mexico and the United States?
No. As you know, sir, a lot of the undocumented didn't come here by crossing the southern border. I mean, there are a variety of different ways.
Did millions of them come here legally to the United States? With a tourist visa, a student visa, a worker's visa, and overstay those visas eventually?
Some are visa overstays, yes, sir.
Okay. So that if you shut down the border, there would still be millions of undocumented workers in the United States of America.
Well, I think we have done a lot for border security. We could always do a lot more, but we have, over the last number of years, done a lot. But the reality is that there are millions of people here undocumented. I'm struck by the fact that something like more than half of them have been here more than 10 years. They're not going away. We don't have the resources to deport 11 million people. So in my judgment, we have to reckon with this population one way or another to make them accountable and to account for them. And so a lot of us want to see us address this population of people in a way that promotes law enforcement and is simply the right thing to do.
So 11 million people, if not one of them crossed the border ever again, there would still be hundreds of thousands, indeed millions of visa overstays, because the only border into the United States of America isn't, to the surprise of many probably, not the border between Mexico and the United States, if not LAX and JFK and Chicago O'Hare, where people enter into this country legally every day and have overstayed their visas. And that we need to also do something, and as we look at the broken immigration system, we should not just focus on that border, because I think focusing on the border really doesn't give us the true nature of the problem that we confront. I'd like to just end, because you were asked earlier about whether or not when people apply for deferred action, if they're asked if they're a gang member. Now, of course, if members of Congress actually filled out the forms or helped people fill out the forms, they'd know that they're asked. So I understand that if you've never filled out one of these forms or your staff has never filled one out, you wouldn't know. But I just wanted to make sure that you gave the right answer, Mr. Secretary. It is asked. They asked them, have you ever, and that was your answer.
That's what we've directed.
But it says, have you ever been arrested for, charged with, convicted of a crime in any country other than the United States? So not only do you ask them about here, but you ask them about the country of origin. And you ask them particularly if they've ever been a gang member, and they must, and I'll just add this just so that we can. If you answer yes, that you've ever been arrested, charged with, convicted of a felony or misdemeanor, including incidents when you were in juvenile court, which usually are sealed, but not in this case. If you want to be a dreamer, you got to tell everybody about everything. If you answered yes, you must include a certified court disposition, arrest record, charging document, sentencing record, except for each arrest unless disclosure is prohibited under state law. So I just wanted to make sure that the committee understood that when people apply for deferred action, they not only have to, if they answer yes to all those questions, all of those documents must be present, and they do ask. And lastly, they have to be fingerprinted. And those fingerprints are checked, Mr. Secretary, by? I just want to make sure. Who checks the fingerprints that the DACA recipients?
I believe it's a combination of agencies. I believe that's an interagency process.
Interagency process, that's what I thought. So it's an interagency process. Thank you so much, Mr. Secretary, for coming before us this day.
Thank you, gentleman from Illinois. I think Mr. Forbes' broader point, Mr. Secretary, and I think he meant to ask you about transcripts as opposed to record. The transcript of a guilty plea or a trial is, you can very well be a member of a gang and never be charged or prosecuted with that. I think that was his broader point. But with that, I would go to the judge from Texas, Judge Gomer.
Thank you, and thank you, Mr. Secretary, for being here. I was hearing my friend from Tennessee, Mr. Cohen, talk about all these threats that are apparently, in his mind, conservatives, but I don't know where his numbers were coming from. They're nothing like what I've been seeing. As I understand, the underwear bomber was certainly not an evangelical Christian, not a conservative. Do you know for sure, was he a member of Al-Qaeda in the Arabian Peninsula? I know that was floated at one time, the underwear bomber.
I would regard him as part of AQAP, yes, sir.
Okay. And I know that was before your watch, obviously. The Boston bombers.
That actually happened when I was at the Department of Defense.
Right.
So I'm very familiar with the case.
Yeah, but you're not going to take credit for letting that happen, though.
I was at DOD, part of the national security
Right.
apparatus of our
Yeah.
government at the time.
You were not in charge of TSA when he got through wearing a bomb
I
in
was
his
not
underwear.
in charge of TSA on December 25, 2009.
All right, thank you. And then Fort Hood, I know some of my colleagues prefer to recall that workplace violence, but when someone is yelling, indicating that he's doing it in the name of Allah, that doesn't seem to be exactly a right-wing, radical, evangelical Christian. But I know there's been a lot of discussion about Francisco Sanchez in San Francisco. And I know as a former judge, we had an ongoing problem. One guy in particular, I sentenced him. I think he had 9 DWIs before he got to my felony court. And I thought, well, if he's going to be a threat, I'll send him to prison. And 6 months later, he's back in my court. He said that he was deported 30 days or so after I sent him to prison. And I come back, and that's what keeps bringing me back to Francisco Sanchez. He was deported 5 times. Secretary, have you analyzed each of those deportations, where they occurred, and where Sanchez may have re-entered the country?
I've looked at a very detailed timeline of each of the 5 removals. I don't, sitting here, recall exactly where he was removed, from what point, from what station. And we don't know, for obvious reasons, how and when he re-entered the United States, or at least I don't know. Maybe in a guilty plea or something, he acknowledged how and when he did it. But sitting here, I don't know I don't know where he re-entered or crossed the border each of those 5 times, sir.
Wouldn't that seem to be important to know where somebody re-enters 5 times?
Yes, absolutely.
I would encourage you, and I would like to find out from somebody in your department where those 5 re-entries were. I mean, were they all down in South Texas, or were some in the Arizona area? Were they California? Because it doesn't seem like we'll ever be able to get a grip on dealing with re-entries by people that come in illegally if we don't know where they're re-entering. The fellow I mentioned that I had dealt with, when he was back in my court, I asked how he came back in, and he said, well, they took him to the border and watched him walk across, and then after the officials that took him to the border drove off, then he came back across and ended up back in our county. And so it just seems like that ought to be where the focus is. Is there any indication that if Mr. Sanchez had been given amnesty somewhere between the first illegal entry and the 5th, that he would not have shot Catherine Steinle? Are there any indications that amnesty would have prevented this?
I'm not sure I understand your question.
Well, I think it's a pretty basic question. The White House is saying that the fault for the shooting of this beautiful young lady in San Francisco was because Republicans have not passed comprehensive immigration reform. And we know we've passed laws, we've appropriated money to build a fence, to build a virtual fence, things that have not been done. And I'm just wondering if we can figure out what the White House is thinking, because obviously an amnesty was going to be part of a comprehensive immigration reform. And I'm just wondering if we all of a sudden declared Mr. Sanchez as being legally here, if that would have kept him from pulling a gun and killing Ms. Steinle. I can't find any correlation to that. I'm just trying to figure out what in the heck the White House thinks would have occurred differently if this man had been granted amnesty. I can't see that it would have prevented her shooting.
Well, I don't, to be honest, sir, I don't know.
And I do prefer you be honest. Thank you.
I am interested in promoting cooperation with local law enforcement for reasons of public safety so that we can more effectively get at people like this individual.
So if there were an amnesty, I don't see how that particularly helps. You just declare everybody legal, then I don't see that it makes a difference. But, and I realize time to run out, but is DHS still shipping people to different parts of the country after they enter illegally, depending on where they have family or where they ask to be shipped?
I don't know that that's our policy, sir.
Are you saying DHS has not done that?
I don't know that that's our policy, as you stated. Some people
I didn't state it was a policy. I'm just saying you've done it.
Some people are able to make bonds. Some people are put in our alternatives to detention program, sir.
So the question was, are you still sending people to different parts of the country after they enter illegally?
Gentleman's time has expired. The Secretary may answer if he wants to.
I don't know logistically where we send people or how they are placed. I do know that a large number of people are making bond, and a large number of people are being placed in our alternatives to detention program.
Chair,
so that would be a yes. You're shipping them around the country. I yield back.
Chair would now recognize the gentleman from Idaho, Mr. Labrador.
Mr. Chairman, Mr. Johnson, thank you for being here today. Ever since Kate Stanley's murder, DHS in San Francisco have been pointing fingers of blame at each other. In fact, I heard several people on the other side saying that it wasn't the fault of ICE that Lopez Sanchez was released. But we had a telephone conference last week with a DHS official, and my congressional staff asked last Tuesday that even if BOP had released Mr. Sanchez to ICE, ICE's answer said was ICE likely would have released him to San Francisco because of the outstanding criminal warrant, despite San Francisco being a known sanctuary city that does not comply with detainers and routinely releases hardened criminal aliens. Does it make sense to release a hardened criminal alien who is already deportable to a jurisdiction that will never return him to you for deportation purposes?
No.
How often does ICE release such criminal aliens to sanctuary cities?
I don't know, but no to your first question.
So if it doesn't make sense, why is ICE saying that they would have released them to?
I was not part of the conversation with your congressional staff, sir, but
well,
I stand by my answer.
You're standing by your answer, but that's not your policy. I mean, it's great to come here to Congress and give us an answer when the policy of the administration is to release these people to these sanctuary cities.
Like I said, it does not make sense to, in response to your question, release somebody.
So what are you going to do about it?
As I said earlier, I think we need to evaluate whether greater discretion needs to be built into a situation where there is a choice or there's a jurisdiction that wants the individual on an arrest warrant and an immigration detainer. I think that there should be some discretion built into what is the best course for purposes of public safety.
But it took this young lady's death to actually get to that determination when this is not the first time this has happened. In fact, you keep telling the American people that they are safe, that we are stopping illegal aliens. But the only reason we knew that Lopez Sanchez was here is because he killed somebody. Because we keep releasing him. He's been detained 5 times. He's been crossed the border. We're not stopping him from entering the United States. We just keep catching him committing crimes once he's here in the United States. I don't know that we can say that America is safe when people like this continue to come into the United States. I'm going to turn the time over to, I'm going to give the rest of my time to the chairman.
I thank the gentleman from Idaho. I think Mr. Labrador's point, Mr. Secretary, and I'm sure given your background as a law enforcement officer and as a prosecutor, I'm sure you can feel and understand the frustration. We've kicked him 5 times. He comes back. He reoffends when he does come back. We put him in federal prison. He violates supervised release. We put him back in federal prison. And he is released to a city where we knew ahead of time this was going to happen. And it'd be one thing to release someone to a jurisdiction for a murder charge, sexual assault, serious drug offense. It'd be one thing to do that so they can prosecute him and particularly if there's a victim involved, that's exactly what you would want to do. But this is an old drug case. If they were going to dismiss it, why didn't they dismiss it while he was in the Bureau of Prisons? Why did it require his presence in San Francisco to decide to dismiss a case? He wasn't going to be a witness anyway. I mean, you get the frustration, and I think it's being directed to you because we perceive that you are in a position to change that. And I know you say cooperation, that you are trying to pursue cooperation. But I think maybe this week, last week, when you were talking to some folks on judiciary, and if I'm wrong, correct me, there are 5 municipalities that have flat out told you they're not going to cooperate with you. So what do we do with them? I mean, if they really are refusing to cooperate, surely we have to have something more than just going back to them and talking to them again. I mean, you work for the United States of America. How in the hell can a city tell you no?
First of all, I intend to reattack on the 5. That was prior to San Francisco. I'm not giving up on the 5. The overwhelming majority have said yes, they are interested. So we're going to continue to push at this. And, sir, I agree totally with the spirit of your question. And I want to evaluate whether some discretion can be built into the process so that when we're faced with a choice like that, we are able to make the best choice for reasons of public safety. I don't argue with you there, sir.
And I'm not going to pick on somebody who used to be a prosecutor because I know you spent a lot of your career standing up for victims. But I swear, when I hear the term sanctuary city, the only sanctuary it ought to be is for law-abiding citizens. That if we're going to have a sanctuary, it ought to be for them. And when a young woman is shot walking with her father, with somebody with this resume, either you got to do something, or we got to do something, or maybe we can do it together. With that, I would recognize the gentleman from Georgia, Mr. Collins.
Thank you, Mr. Chairman. Again, I share this chairman's frustration and other frustrations that have been here, because at a certain point in time, you say, again, that they just don't want to cooperate. 5 cities said we're just not going to cooperate. I was just looking on your website, DHS website, you've got a vast array that you deal with. I want to get ahead of the game. Let's decide, because I'm from a state level, I was in a state legislature, and I know cities and states are struggling financially right now. They have, as you've used the term, which I do not agree with, that this is simply a prosecutorial discretion issue, resources issue. One of the things is cybersecurity that you deal with, and you enforce cybersecurity laws, you work with law enforcement on the local and state level to do that. What if now they just don't have the resources to do that, and they said, you know, we're just not going to enforce that. We're not going to cooperate with you, Mr. Secretary. Would you have an opinion on that?
Absolutely. We would engage. We would encourage them to do otherwise, presumably. Yes, sir.
Okay, but we would it is an interesting thing, because you said to Mr. Smith earlier, and there's other things, you know, from economic security, everything, you said you had no opinion on sanctuary cities. But yet to the chairman just now, you said you agree with the spirit of his question.
Yes.
So what is it? Do you have an opinion? Do you have a spirit? Do you have a sudden moving internally? What do you feel about this issue? Why can we not have the United States government pass law, and then you have an opinion? You either have an opinion, you don't have an opinion, you agree with the spirit, you don't agree with the spirit. The American people, it's just hard to understand here.
Well, let me make this clear. I believe that the most effective way to address and enhance public safety is to work cooperatively with state and local law enforcement. As a result of our prior...
So I'm going to stop right there, though. So the supremacy clause
May I finish
is
this?
optional.
May I finish
Is
my
the
sentence?
supremacy clause optional? I'll let you answer.
May I finish my sentence?
Go ahead.
I believe that as a result of the prior policy, we were inhibited in our ability to promote public safety. With the new policy, I believe we'll be in a much better position to work effectively and cooperatively with law enforcement. I do not believe that federal legislation mandating the behavior of a lot of sheriffs and police chiefs is the way to go. I believe it will lead to more litigation, more controversy, and it will be counterproductive.
The supremacy clause question you never answered, but the question you just said there, so you don't believe that mandating what law enforcement in this country does from a congressional perspective, because we're the only ones that Congress does the law writing.
I do not believe...
So they can pick and choose what they want to just overwhelmingly.
I do not believe that the federal government and the U.S. Congress should mandate the behavior of state and local law enforcement.
So civil rights could be optional?
The most effective way to do this is cooperatively with the new program, and I believe it is going to yield very positive results, sir.
In the spirit of your question, so civil rights are optional for states and locals to enforce?
I don't think that mandating an approach by this Congress is the way to go. I think it'll be hugely counterproductive, and it'll set
So
back
the Civil Rights Act was counterproductive?
My public safety efforts in this regard.
No, Mr. Johnson, I want to go back to what you're saying because it goes at the heart of what we're saying. So you're saying the Civil Rights Act was overreach. You're saying that they shouldn't be enforcing this. I think we're getting at the issue of here because at a certain point in time, when does it become just wholesale abandonment of prosecutorial discretion when you just say we're not going to do this? I agree with prosecutorial discretion. But what you're saying, if you just take a whole class off the table, in the best sentiments that you want, because it leads to other issues like the earned income tax credit, or folks are eligible. The decisions you have affect other issues than simply saying we're going to hold somebody or not. We're going to address the earned income tax credit issue with legislation I'm going to draw, but it has more to do with what do we pick and choose to enforce. And I don't think, I'm not sure still what your opinion is, because you've, again, not answered it. You just said we'll work with them. I just don't, my question is, before you come back next year, whenever it is, if we have this hearing again, is what if some of these agencies decided they didn't want to enforce something you thought they should? Where's the screaming? Where's the outrage? Where's the, when should Congress pass anything? If there is no supremacy clause, if there is no work that what we do to protect civil rights, to protect other things, when does each department get to decide that they're not going to enforce their federal jurisdiction on states and localities who simply say, you know, we're not going to do it right now?
May I answer?
Well, I stopped and asked a question. That's your response time.
Yes. All right. I have 2 seconds.
No, the chairman will give you all the time. If you'll answer that, I will give you all the time you need.
I want to enforce the law. May I, Chairman?
Yes, sir. You may answer the
I want to
question.
enforce the law in a way that maximizes public safety and border security. That means going after the criminals. A big problem with doing that are the number of jurisdictions, I don't know what label you want to put on them, sanctuary cities or otherwise, that have erected ordinances, laws, policies that inhibit cooperating with immigration enforcement. In my judgment, and in the judgment of a lot of other border security, immigration enforcement experts, the way to most effectively work with these jurisdictions, again, is a cooperative one, not by hitting them over the head with federal legislation that will engender a lot more litigation. And I believe we're on the path to do that, sir.
Mr. Secretary, I respect that opinion. I think what you have opened up, though, is a Pandora's box on other things that they don't want to enforce because of other reasons that they'll come up with. And just because this is a political issue for this administration, they're going to let that go. But you do open a Pandora's box to what they will enforce and what they won't enforce. And that's not what the average American understands when they learn black letter law and they understand what's right and what's wrong. With that, I yield back.
Gentleman's time has expired. The chair would now recognize the gentleman from Texas, Judge Poe.
Thank you, Mr. Chairman. Thank you, Mr. Secretary, for being here. Once again, thank you for coming to Houston. Appreciate your personal involvement and FEMA doing an excellent job during the floods of May, as I refer to them. Direct some questions about foreign fighters not only from the United States going to help ISIS, but foreign fighters in other countries. We know that ISIS uses social media, Twitter, others, to recruit, to raise money, and to spread their propaganda. What is DHS doing to counteract that?
A number of things, sir. Thank you for that question. First of all, to deal with the foreign fighter issue, one of the things we did last year was to add information fields to the ESTA system, the electronic system for travel authorization, so that we know more about people who want to travel to the United States from countries for which we do not require a visa. We have also developed and are developing an additional set of security assurances that we can get from visa waiver countries, because a large number of foreign fighters, as you know, I'm sure, are coming from and returning to countries for which we do not require a visa. And so I want to see us enhance the security assurances we get from these countries with respect to people who travel from those countries to this country. Additionally, on the international level, we've done a lot. I sat in on and represented the U.S. in the UN Security Council session in May on the issue of foreign fighters. And in terms of our efforts here at home, one of the things that we're spending a lot of time on, that I'm spending a lot of time on, are what we refer to as CVE engagements in communities in the United States. Like Houston, for example, I had a very good session in Houston on the same visit where you and I were together at your middle school. And so in my view, enhancing and refining our CVE efforts in this country, which DHS participates in, which the FBI participates in, and other law enforcement agencies, along with state and local law enforcement, is a priority, given how the global terrorist threat is evolving.
Other thing I want to discuss with you is repatriation and what the law is currently in the United States and how it's being implemented, if it is. We have this problem that a person comes to this country, commits a crime, goes to federal prison. While in prison, the system works, he's ordered deported. The country doesn't take him back. 6 months later, he's released back across America. What are we doing to those countries to encourage them, you take your convicted criminals back?
The State Department and I have been in dialogue about this, and we have been in dialogue with countries that are slow to repatriate people. I have personally had this discussion with my Chinese counterparts when I was in Beijing in April, and I believe we made some progress there where they agreed to additional repatriation flights. And so China is one of the big ones. We made good progress there, but I think, and I agree, there is more work to do in that regard.
If I understand, China, number one, the other top five, Vietnam, Cuba, India, Jamaica, refused to take back their lawfully deported citizens. Doesn't the law already allow the State Department, under some circumstances similar to that scenario, to revoke visas from that country?
I believe it does.
Do you encourage the State Department to do that when appropriate?
I would not at this time encourage that, sir. No, sir.
All right. Thank you, Mr. Chairman. I will yield back.
Judge Hills back. The chair would now recognize my friend from Florida, Mr. Deutsch.
Thank you, Mr. Chairman. Secretary Johnson, thanks for being with us today. And I want to applaud your recent decision to change detention practices for families awaiting their appearance in immigration court. And that's because many of those awaiting their day in court are mothers with young children. Why they've fled their home countries is no mystery. Central America has been gripped by transnational gang violence, and these families are not, as Republican presidential candidate Donald Trump has described, to be violent criminals, drug dealers, and rapists, these families are fleeing violent criminals, drug dealers, and rapists. And many of the mothers currently in custody have suffered sexual abuse, witnessed extreme violence, and have received death threats against themselves and their children. How we treat them, Mr. Secretary, colors the reputation of the United States on the international stage, and our practice of welcoming these most vulnerable families by essentially incarcerating them was wrong and called for change. After all, the purpose of civil detention is to ensure that individuals show up in immigration court. These families have every reason to do so. They pose no flight risk, and indeed, for many of them, returning home would mean risking death. Likewise, we have no national interest in subjecting children of any nationality to the detrimental psychological impact of detention, which has been documented in several recent studies. Your written testimony includes plans to rapidly increase the use of ATDs, or alternatives to detention, and it deserves our praise. Expanding the use of ATDs from 23,000 in 2014 to 53,000 in 2016 is the morally respectable and the fiscally responsible thing to do. I'm encouraged by this development, and I want to encourage you to expand the use of ATDs throughout our greater immigration enforcement system. Our over-reliance on immigrant detention has disturbing implications. A recent report by Detention Watch Network revealed that ICE often agrees to contracts with for-profit detention corporations that include guaranteed minimum numbers of detainees for specific facilities each day. These local lockup quotas in detention contracts obligate ICE to pay for a minimum number of immigration detention beds at specific facilities referred to in contracts as guaranteed minimums, and for the government to contractually guarantee specific detention center prepaid numbers of detainees each day is a waste of taxpayer dollars, it's a violation of best practices of law enforcement, and it is an affront to our basic concept of justice in America. The financial implications for taxpayers were also raised in a November 2014 GAO report, and that's because such quotas often pad the profits of private prison companies at taxpayer expense, even when slots go unfilled. Certainly, detention is invaluable to law enforcement. It's invaluable when dealing with immigrants who officers determine are flight risks or whose release could threaten public safety. But detention is intended to be one of many tools available to ICE to ensure individuals show up for immigration court, not the only one. But evidence of local lockup quotas may just be the latest symptom of the real disease, which is the mandate imposed by Congress in the annual Homeland Security appropriations that requires ICE to maintain the detention of 34,000 individuals each day. This detention bed mandate costs taxpayers over $2 billion a year, $5.5 million per day to enforce, because placing someone in detention for nearly $160 a day is far more expensive than proven alternatives like ankle bracelets and supervised release, which are just as effective and far more humane at a fraction of the cost. We could save taxpayers nearly $15 billion over the next decade through the greater use of alternatives to detention, but as sensible and as fiscally sound as this policy may be, I'm concerned that the incorporation of local quotas into ICE contracts is only further entrenching the national detention bed mandate into our communities. And I have just a series of questions I'd ask. You can respond now, or you can provide responses after, Mr. Secretary. I'd like to know if you're aware of ICE's practice of signing these contracts with private detention companies that contain lockup quotas. We're interested to know whether, during contract negotiations, private detention companies insist that contracts for specific facilities contain these provisions. Is it the lockup quota for a specific facility? Is that lockup quota negotiable during negotiations? And finally, the November 2014 GAO report that addressed lockup quotas for specific facilities was critical of those. And I'd like to know whether DHS made any policy changes in response to that report addressing lockup quotas in contracts with private detention companies. You're moving in the right direction, Mr. Secretary, and I hope you can respond to these questions so that we can save the taxpayers money, so that we can have a policy that is more humane as well. Please.
I would refer you to the directive that I issued on June 24th and the announcement concerning family detention, which you alluded to in your statement. And I'd like to take those questions for the record, sir.
Gentleman from Florida yields back. The chair will now recognize the gentleman from Michigan, Mr. Bishop.
Thank you, Mr. Chair. And thank you, Mr. Secretary, for being here today. I have a number of questions I intended to ask about cybersecurity, but as I sit here, and we've now been through most of the members on the panel, I need to ask you a question, and I feel like I need to ask you it as not a member of Congress, not a Republican or Democrat, but just as an American. And you were a former prosecutor. I respect your insight on this, and I hope that you can share your thoughts in a candid way. And this is actually, a follow-up question to, in particular, Mr. Collins and Mr. Gowdy's questions. We're a nation of laws, and as I sit here and listen to this discussion, we are a nation of laws. It's what differentiates. It's what distinguishes us as a civilized society. And in this country, we don't discriminate when it comes to the application of the law. In fact, the Fifth Amendment of our Constitution, the Equal Protection Doctrine, which extends to the states as well, specifically says that it requires us, people in similar circumstances, are to be treated in the same way, in similar ways. And as I think about sanctuary cities and how they have been applied and how we have discussed them in this context, how has this continued on? How do we continue to accept sanctuary cities and its selective application of law? And I would say historically, Americans would view the selective enforcement of laws as a sign of tyrannical government. It's inherently unjust. It's a blatant misuse and abuse of power to allow for such an environment to exist. And I'm wondering how we expect Americans to respect the rule of law if the administration's policy is to enforce them based solely on edicts from rulers rather than from actual rule of law.
Is your question with regard to sanctuary cities?
It is with regard to sanctuary cities, and to me, as a person who represents a good 700,000 people, one of the very issues that I hear about every day is the fact that we have lost the ability to enforce the laws as they are written, that we do it in such a way that applies in one way to one group, in such a way, and another way to another group. And when that happens, we lose the rule of law, and folks just simply do not want to comply with the law.
Well, if I could answer it this way. Last year, when I took a look at the growing number of jurisdictions, states, cities, counties, that were refusing to cooperate with my own department in the enforcement of our immigration laws, I said this is something that we have to fix because the number is growing and it's affecting public safety in my judgment. And so we took a hard look at the Secure Communities program. We saw how it was becoming an item of litigation in court, and the defendant was losing in court in these cases. And we look at the political controversy that had been built up around Secure Communities. I concluded that we needed to make a clean break with the past and develop a fresh program that I believe is going to fix the situation and promote public safety. And so that's what we've been doing since the announcement of the new program in November. Unfortunately, there's no one-size-fits-all answer to this because a lot of these jurisdictions have erected different types of limitations on their ability to cooperate with us.
May I,
we
sir?
have to do this one by one.
And I gathered that from the testimony, and I know my question was a duplication of many other questions. I apologize for the fact that I'm asking a question that's already been answered. But the frustration is, how is it possible that we live in a country of laws, a nation of laws, that allows its local jurisdictions to set up these little buffer areas where the law does not apply to them? And I know that we've heard about the Fourth Amendment and the concerns about the Fourth Amendment, and I respect the Fourth Amendment, but we can't hide behind the Fourth Amendment when the rest of the Constitution applies, when in fact it's endangering citizens and when it really prevents us from applying the rule of law in a way that's consistent with every American. And I've just sit here in frustration as I listen to this discussion. I'm wondering, why isn't the federal government insisting upon these local units of government following the rule of law and not allowing this to happen, not allowing this selective application to happen?
Well, again, I believe that the best approach is a constructive one, and I believe that it will lead to much better results. It will raise the level of trust and cooperation, because we have not been in a good place when it comes to a lot of jurisdictions that are just very distrustful of our immigration enforcement efforts, and I want to put us in a better place as long as I'm Secretary.
Gentleman yields back. The chair will now recognize the gentleman from Texas, former United States Attorney, Mr. Ratcliffe.
Thank you, Mr. Chairman. Secretary Johnson, earlier today, as you gave your testimony and responded, I think, to the first question, you said something, you said, and I'm quoting you here, "It is a fiction to say that we are not enforcing the law," end quote, when it comes to deporting criminal aliens. Did I hear you correctly?
Yes, sir.
Okay. And in fairness, the department, clearly is deporting some folks. But I'd hope that you'd agree with me that what is not a fiction is that this administration has been attempting to change the law when it comes to deporting criminal aliens, a fact reflected by the President's executive orders back in November.
I disagree.
Why would you disagree with that?
Because in my judgment and in the judgment of the Department of Justice, our executive actions were within and are within our existing legal authority.
I'm not talking about within the authority. I'm asking about changing the law here.
Well, if it's in your legal authority to act, you're not by definition changing the law.
Well, let me ask you about that then. You do agree with me that the President's executive orders in November attempts to allow executive amnesty to 4 to 5 million illegal aliens. You'd agree with that?
Not the way you've characterized it, no.
All right. Then how would you characterize it?
One of the executive actions I signed was to create a program by which we can offer deferred action on a case-by-case basis to those who come forward and who meet certain criteria and who, in the judgment of the agency, should be given deferred action.
Which could result in amnesty to up to 4 to 5 million folks here illegally.
I don't agree with that. That's not my definition of amnesty.
Okay. Well, you've gone on record regardless of saying that you think the President's actions in that regard, that he acted constitutionally.
Yes, sir.
All right. And I've gone on record as saying I don't think that he has acted constitutionally. And right now, a federal judge in a court of appeals in the Fifth Circuit has agreed with me that the President's request to lift that stay and to proceed to take those actions shouldn't be allowed. But you've been asked today and talked a lot today about the issue of prosecutorial discretion, and we're both former prosecutors. So I'd like to ask you about something that you said previously in a hearing last year. You said, and I'm quoting, "There comes a point when something amounts to a wholesale abandonment to enforce a duly enacted constitutional law that is beyond simple prosecutorial discretion," end quote. Does that sound like something you said?
That sounds like me, yes.
Okay. And do you believe that?
I still do.
Okay. I know the answer to this question, but I'm asking anyway. Do you think that DHS has already crossed that line by suspending the law for almost 5 million folks that are here illegally?
Well, again, I would not characterize our executive actions that way, and I would refer you to the opinion of the DOJ Office of Legal Counsel issued in November in terms of where that line exists. I thought it was a pretty thoughtful discussion.
Okay, but again, you don't think that wherever you think that line is, you don't think DHS has crossed it at this point?
No, sir.
Okay, so that begs the question.
I know that there are people who disagree with me, but no.
Sure, and so that begs the question for me, what would it take, in your opinion, for DHS to cross that line? Because I think there's every possibility that this president will attempt to move this line again. And so if this president were to seek to grant deferred action to, say, all 11 or 12 million unlawful aliens in this country, I'd like to hear you on the record on whether or not you think that would cross this line.
Well, again, I'm no longer practicing law, I'm just the secretary. And so I think what you're asking me for is a legal judgment. And again, I believe that the opinion of DOJ's Office of Legal Counsel has a pretty good discussion of this exact topic. And I recall when I read it agreeing with the analysis. I don't have it with me, but I recall then agreeing with the
Well, let me ask you about that. So does that analysis extend, since you had a good discussion with them, would it extend to possibly 11 or 12 million folks?
Doubtful.
And if it did, would you have an opinion on whether it should?
Well, it depends on the circumstances, but I would say I doubt it.
So when you say you doubt it, you doubt that amnesty should be granted to 11 or 12 million people?
Well, if you're referring to the estimated population of undocumented in this country, a lot of those people are and should be priorities for removal. So in my judgment, someone who is a priority for removal should not receive deferred action.
I see my time's expired. Mr. Chairman, I yield back.
Gentleman yields back. Mr. Secretary, I thought we were kind of getting towards the end, and then two members came up. Would you want or desire a short break, or you want to keep marching on and hopes that we?
I'm happy to keep going for a little while longer.
Okay.
Thank you for asking.
Yes, sir. The gentleman from New York, my friend Mr. Hakeem Jeffries, is recognized.
Thank the distinguished chair from South Carolina, my good friend, and want to thank the Secretary for your presence here today, your patience, as well as the tremendous job that I believe you've done as the Secretary of Homeland Security and your prior service
And
to
who've
this
known you
country.
a lot longer than the gentleman from South Carolina.
I want to begin by just asking that there are 11 million undocumented immigrants in this country, approximately. Is that correct?
That is a Pew estimate from a few years ago, 11.3, yes.
Okay, and has this Congress or any other Congress ever given the Department of Homeland Security the resources that would be required to deport all 11 million undocumented immigrants?
No.
And so therefore, is it reasonable to have a priority policy that focuses on those undocumented immigrants who would potentially pose the most danger to the American citizens?
Yes.
Is that what DHS has done?
Yes.
Okay. In New York City, we've got a technology and innovation economy that has begun to develop in some significant ways for our city and our state, as has been the case across the nation. And I've been very supportive of that. Many within the technology sector have indicated that there's approximately a 20% vacancy rate, if not more, of jobs that they cannot fill here in America. And that's been part of the impetus for an increase in H-1B visas, which I've supported. I was disturbed, however, by the revelations as to what appears to have taken place down in Florida at the Disney company. I just wanted to ask a few questions about that. And before I did, I just asked unanimous consent that an article from the New York Times dated June 3rd, 2015, titled "Pink Slips at Disney, but First, Training Foreign Replacements," be entered into the record?
Without objection.
And so as I understand it, approximately 250 Disney workers were laid off at some point in 2014, and then many were replaced by immigrants hired by an outsourcing company based in India. Is that correct?
That's basically my understanding, yes.
And is it also your understanding
That's
that
my
some
understanding of the public reporting of it. The matter is under investigation.
Okay, so as I understand it, those individuals were allegedly laid off and then asked prior to their departure to train individuals from this, connected to this company, to replace them who were given H-1B visas. Is that the current allegation as you understand it?
Yes, I believe so, but the matter is under investigation.
Okay. And so I understand what the law is in this area. Am I correct that the H-1B visa program, which provides a limited number of temporary visas, I believe it's somewhere in the neighborhood of 85,000 a year for foreigners with computer science, engineering, or other advanced skills to fill jobs in American companies when American workers are not otherwise available? Is that a correct description of the program?
That sounds basically correct to me, sir. Yes, sir.
And if your investigation determines that this particular company or any other company violated the actual law related to the issuance of H-1B visas and the employment constraints, what are the potential consequences related to a violation of the policy?
Well, that's actually something where I think Congress may be able to help us. It's my understanding that we don't have enough tools legally to deal with that kind of situation, assuming it occurs. And so what people have told me is that we could use some help from Congress to bolster our enforcement capabilities in a situation such as that one. And I can get you a more informed opinion on that answer, but that's what I'm advised of.
Well, thank you, Mr. Secretary. I'd be interested in your further thoughts in that area, and I yield back.
Chair, thanks. This is from New York. The chair will now recognize the gentleman from Texas, Mr. Farenthold.
Thank you, Mr. Chairman. Secretary Johnson, thank you for being here. We appreciate your service to the country. First of all, just can you give me a quick response with a percentage? How secure do you think our southern border is?
How secure?
How secure is southern border? Percentage.
It's tough to quantify by percentage. As I mentioned earlier, I think that over the last 15 years, we've come a long way in our border security.
So we 50, 75, you know, what do you think? You can't put a number on it. I mean, how can you measure results if you can't quantify it?
The percentage of the border that is secure?
Or how secure is it? What percentage of folks are getting away that are crossing? You have any idea?
Apprehensions, which are an indicator of total attempts to cross the border illegally, have gone down considerably in the
So you can't give me a number. That's fine. I've spent some time on our southern border talking to the men and women actually in the field. I represent South Texas, used to represent the border down at Brownsville. So it's kind of right in the backyard of the district that I represent. And I have to tell you, I'm hearing a lot of frustration from the rank and file of the Border Patrol. I'm hearing restrictions on overtime are causing smaller teams of Border Patrol agents to be sent in pursuit of crossers, and that prosecutorial discretion means that aliens and drug smugglers that our agents risk their lives to apprehend are just getting released. I've also recently heard the administration is planning to cut proposed fleet purchases to replace the vehicles that our Border Patrol agents desperately need to secure our borders. These men and women are brave in danger in a very rough environment. I've actually did a ride-along out in the brush, and I understand that it's tough to protect this country, especially in some of the terrain in South Texas. But the administration's policy seemed to completely ignore the fact that they need the equipment and the manpower to do what they need to do, and it seems like they're almost intentionally reducing the morale of Border Patrol agents. Tell me, if you had to be on the border working shifts with the men and women in uniform, and you know that in all likelihood that you're putting your life in danger to catch illegal aliens and dangerous drug smugglers, that most likely end up getting released from custody and walking away in the end, how would you feel about it?
Well, again, let me answer it this way, if I may. Under our new policy, those apprehended at the border are priorities for removal. And those apprehended who arrived in this country after January 1, 2014 are priorities for removal.
But what I'm hearing from the Border Patrol agents is they're catching somebody, and then just a few days later, they're catching the same person again. So you deport them, they're taken basically back across the bridge, and my understanding of the contracts with the Coyotes is you get 3 tries to get across.
That person should be a priority for removal. And I believe that in our current budget request to Congress, we are asking for more surveillance technology, more border security to do a better job. We've come a long way in the last 15 years. I'm very pleased about that, but I know that there's a lot more to do.
And I know Mr. Gowdy's bill helps with some of that, and we look forward to getting that through Congress. Let me take it from the other side. If you were an alien or a drug smuggler with the knowledge that as long as you don't bring more than a handful of people across or a certain amount of drugs under the prosecutorial discretion limits that everybody knows, you'd get away scot-free. Wouldn't that just be an incentive to keep going? I mean, it doesn't seem like that would be a deterrent.
I disagree. If those apprehended at the border, irrespective of whether they have narcotics with them, irrespective of whether they're smuggling, are priorities for removal.
All right, but what about the drug smugglers with small amounts of drugs, or the coyotes that are only bringing over 3 folks? My understanding from the Border Patrol agents is that if you have less than 4, you basically walk as the coyote.
We've also, beginning last year, cracked down on the smuggling organizations. That's something that the Department of Justice and I instituted last summer.
But are you telling me that it's not a fact that if you have a small number of aliens or a small amount of drugs with you, you're certainly not going to face any jail time? At worst, you're going to be taken back across the border.
Well, that's a matter of law enforcement and prosecutorial discretion by the Department of Justice. I do know that since last year, since about a year ago, we have prioritized going after the coyote organizations.
All right, well, thank you very much. I see I've only got 5 seconds left, so I'll yield back the remainder.
The gentleman yields back. Mr. Secretary, you've been here a good long while. I know you have other commitments. I wanted to recognize Mr. Gutierrez for any closing reflections that he may have, and then I wanted, at the chairman's request, to mention a couple of matters, and then we'll have you out of here. Mr. Gutierrez.
First, thank you, Mr. Gowdy, for your excellent presiding over these hearings. One of the reasons, Mr. Secretary, is one of us always stays behind as part of the minority to protect the interests of the minority, and in this case, yours. It was totally unnecessary. As you can see, the chairman is very well balanced and even-handed in everything. I just want to, just for the record, because I think it's very important, I want to say to you, Mr. Gowdy, I share with you the same anguish and pain as I know the Secretary does, and every American, at the death of that woman. And that nobody has come here to look for excuses or anything else. That woman should be alive. That woman should be enjoying life in the United States of America. Mr. Lopez should never have been allowed on the streets of our nation again. But I think it is important that we have the facts straight, that our system does work, and sometimes it fails us. He was sentenced 63 months, 51 months, 21 months, 46 months. 4 consecutive times he was sentenced to over 10 years, and he served them, over 10 years in jail because he illegally entered the United States of America time and time again, violating. I mean, this is a career criminal that we had on our hands. So I think we should just try to figure out a way, because I really believe this, and I want to put this on the record, even though it might cause you great damage back in South Carolina. I really believe that if you and I and the Secretary and men and women who wanted to solve the problem, we could solve this problem. We could save future people from harm. This man is not an immigrant. Immigrants come here to work hard, sweat, and toil. We should be warm and receiving. This man's a foreigner who came here to cause damage. And let's fix our broken immigration system so we can get rid of the foreigners that come here to cause damage and harm and welcome the immigrants. Thank you so much, Mr. Secretary, for a long day here with us.
I thank the gentleman from Illinois and for what he said, and for being always very consistent. And the entire time I've been on this committee, you have zero tolerance for those who come here to do harm to anyone. And that has been your position as long as I've known you. Mr. Secretary, the chairman wanted me to mention really quickly to you that he had written in March about alleged fraud in the Special Immigrant Justice Visa Program, and he pledged again his willingness to work with you to cooperate to identify any of the sources of the fraud so that it can be eliminated. I can tell by the look on your face, you may, I'm sure you get a lot of letters. You may not specifically recall that one, but I know the folks behind you will bring it up. I think it was in March of this year, but if not, if we need to get you another copy of that, we will. Secondarily, it sounds like you are well aware of the Sentencing Commission's change and that you and the Department of Justice are working on that. I'm not going to ask you about the Fifth Circuit. You couldn't comment on it. I'm not going to ask about it anyway. The only thing I would add, what my friend from Illinois said, there are parts of immigration that you and I and Mr. Gutierrez are probably not ever going to agree on, and that's good. That's fine. That's the beauty of a democracy. I think what we can all agree on is to return someone with his criminal history
to a jurisdiction that had no intention whatsoever of ever prosecuting him, and in the process, he is released, should be an affront to everyone, irrespective of political ideation. San Francisco had no intention of prosecuting him. They dismissed the case. You can dismiss it when he's halfway through his federal prison sentence, just as easily as you can when he's in your custody. So I will tell you, I am happy to work within, and I get the commandeering clause, I get the due process considerations, I know that those are legitimate, you've got court cases out there. If there's a way to get around that, you know, what I find instructive, I don't doubt your power of persuasion, and I know that you're going to go back and talk to those 5 municipalities that told you no. But even after this young woman was murdered, San Francisco is already on the record saying they're not going to change their policy. So when you have a city like that, I don't know that cooperation and persuasion is going to work. So we may need to consider something else. I mean, when I look at you, I see the Secretary of Homeland Security for the United States of America. He shouldn't have to ask San Francisco. You shouldn't have to get their cooperation. You, to me, outrank the city supervisors in San Francisco. So with that, thank you for your patience. You have a really hard job, and we appreciate your current service and your previous service. With that, we are adjourned.